2022. Prayer is allowed. This the matter after 2 weeks. After 2 weeks. Deeply obliged.
May I please?
May I please, Your Lordship,
Lordship.
I'd like to mention item 55
Huh.
in the supplementary list today.
Hmm.
We have just received the signed affidavit. We are filing today as we speak. Lord, may kindly
55.
notice.
55.
Yes, my lord.
You are for?
For the Assam Agriculture University, my lord. And for the petition.
Mr.
S. Sharma.
S. Sharma, Learned Standing Council, Assam Agriculture University,
Yes, ma'am.
submits that phrase that he may be granted. A phrase for and is granted 2 weeks time to file. 2 weeks time to file affidavit in opposition. Next para. Mr. S. D. Learned Council, but prisoner is present.
May I please? Lordship? I beg to mention item number 56 of supplementary list, my lord. Matter may be adjourned for the day, my lord.
Why?
We have some personal difficulty today.
You are Mr.
I am in.
Mr. I Amin Learned Council for the petitioner. Praised for listing of the matter after 2 weeks. Praise allowed list after 2 weeks.
Obliged.
May I please, Your Lordship? I beg to mention item number 7. Lordship, some instruction are still awaited from the petitioner, therefore kindly adjourn the matter.
Item number 7.
7.
What is there? What is the matter about?
I'm not aware, Lordship.
Then 2021. You are Miss
M. Teronpi,
M. Terongpi, Learned Council, appearing on behalf of
N.K. Kolita.
Mr. N.K. Kalita, Learned Council for the petitioner. This matter after 4 weeks. 3 weeks.
May it please, Your Lordship.
Yes.
I beg to mention in regard to item number 30, Your Lordship.
20.
We are for, yes, Your Lordship.
Ah.
We are for the respondents. Today I am seeking for adjournment. Your Lordship. Kindly fix the matter after 3 weeks.
On the prayer, Mr. S. Datta, Learned
Yes.
Council for respondent 1, 2, and 3. And as agreed to by Learned, who is for the petitioner?
Your Lordship,
Learned Council for the petitioner. Let this matter be discussed
S. Gauhati.
after 2 weeks. You have taken consent
Yes, Your Lordship.
after 2 weeks. 3 weeks, make it 3 weeks. Yes.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 26. Lordship, on the request of the conducting council, the matter may be adjourned for today, Lordship.
Why?
She has some personal difficulties, Lordship.
Yeah. On the
SSG.
ground that SSG
Yes, Lordship.
has some personal difficulty today, MS, your name.
I am MS DR Bangshari. I am appearing on behalf of SSGR.
You are?
DR Bangshari.
Got it. Praise for listing of matter up to 2 weeks. Praise the Lord, list up to 2 weeks. This is the matter up to 2. Yes.
Much obliged, Lordship.
Please, Your Lordships, I beg to mention item 15 in the daily policy today.
15.
Yes, my lords.
Yes.
It's a joint adjournment that we
Oh,
seek.
I'm appearing for the Agriculture Department, Lordship. Some development has taken place, which I also came to know yesterday night only, that I have to verify and bring it on record. Both sides will have to bring it on record. Lordship may take it out after 2 weeks.
On the joint prayer of Mr.
S. Sharma, I appear on behalf of
S. Sharma, Learned Council, appearing on behalf of Mr.
Mr. T. Wapangla.
T. Wapangla, Learned Council, MST Wapangla, Learned Council, and Mr. B. Chaudhary, Learned Council for
Agriculture.
Learned Standing Council Agriculture. Let this matter be listed after 3 weeks.
Yes.
3 weeks.
Obliged.
May it please, Your Lordship. Your Lordship, in regard to item number 30, there is an interim prayer. For the
Motor
petitioner.
passed earlier.
Much.
Daily list 1 and 2, please, party.
May it please, Your Lordship.
Yes.
This interim application has been filed for impleading. There is a nodal officers as a respondent in the that is the rate petition. But one thing is, Lordship, in the last occasion, it has been known that only the that is the CRPF nodal officer CRPF is required in this case. So in my IA, page 128, Lordship may retain that is a nodal officer CRPF. The rest of the respondent impleading respondent may be struck out, Lordship. 128.
Ah,
7 may be retained, Lordship.
rest,
Rest may be struck out, Lordship, is not needed. In both the cases, same situation. In
Okay.
another case also, on item number 2.
Lordship, last order,
ah,
27, 26,
hmm.
third paragraph from bottom, Lordship, that they have to make necessary corrections in the parties. Other respondents are also not correctly, so that is their observation of this honorable court.
Lordship,
You withdraw and file a fresh.
yes, Lordship, that will
It's
be
better.
better.
Let
That
us
will be
not make
better.
it clumsy.
Better.
Okay.
Lordship. Yes, Lordship.
Mister,
He does, Tapan does.
he does learn counsel for the applicant pressed for withdrawal of this interlocutory application with the liberty to file afresh. Mr. MS
I am in item 2, B. Sharma.
B. Sharma,
Item number 1, Lordship.
Mr. MS
On
Are
behalf
they-
of S. Roy.
learned counsel for appearing for the SS Roy, learned counsel for the opposite party. SS Roy is present and accordingly, no, the prayer for withdrawal is accepted and accordingly, I stands closed on withdrawal with a liberty to file afresh.
Date may be fixed, Lordship.
Wow, how can we put that? Same order in attempt to MS
B. Sharma.
B. Sharma. CGC.
CGC.
SS Roy is also CGC. Okay.
Highly obliged.
Wait, please, Your Lordship. This matter, Lordship, the petitioner is aggrieved with the appointment of respondent number 5 for the Anganwadi helper.
Hmm.
On the last occasion, a report was submitted, completing the service of the respondent number 5, Lordship. And no one has appeared, I think.
It's okay. Notice is already been served.
Yes,
We'll
Lordship.
hear the matter.
Instruction, I have received instruction, Lordship, affidavit has been.
Saying what? What's saying what? What is the instruction?
The application of the petitioner was rejected as because non-matriculate candidate as Srimati Himavati Devi was selected in the selection process as her qualification HSLC pass. Private respondent was selected because she passed HSLC examination and petitioner under matriculate.
So requirement is matriculation.
Yes.
Then madam, what is there?
That is, Lordship, but in advertisement, Lordship, kindly come to page number 13
Ah,
and this 14, Lordship, next page. Serial number 20, Lordship.
14.
Page number 14, serial number 20.
Ah,
Lordship, this Bagarpar, Kazirpar, Manipuri Thapar Muslim community. This is the center of the petitioner, Lordship.
hmm.
It is specifically mentioned in the advertisement, this is for Muslim community, Lordship.
Hmm.
And
And selection is made to
met to respond number 5,
who is not a Muslim community.
not Muslim, Lordship.
Who is respondent number 5?
5 is Himavati Devi, Lordship. They are not qualified. Therefore, Muslim candidates, two Muslim candidates applied for the post. Both are not qualified. Therefore, Himavati Devi was appointed.
Then you have to change it
Yes, Lordship, that is the.
when you have already reserved.
Detail affidavit is required, Lordship. Instructions are in detail.
Let them
Lordship.
file affidavit, Lordship. Let them file the affidavit, Lordship.
No, see, it's very simple. You go for fresh selection.
That may be.
She is also not eligible.
Tell-
She doesn't have the
Explaining that.
education qualification And the respondent whom you have selected is not from Muslim community.
Lordship, I have to
Both are not eligible.
kindly
Kindly
grant
come to
2
page
weeks' time. I will file my affidavit and after that take it
I
for.
will set aside the selection and you go for fresh selection.
The interim is there, Lordship.
Lordship, that though there is the interim, I think the respondent might have joined the center and she is working there. Lordship, for the one
But
slot,
what you will be benefited? Even if there is a fresh advertisement, you don't have you are not eligible.
Lordship, kindly come to page number 15, Lordship. That is the eligibility criteria. Serial 5, Lordship, Roman 5.
Page 15.
Yes, Lordship, serial number 5.
Candidate for the postal helper should have the SSLC.
Pass the border. And Lordship, in case there is no such qualified candidate, education qualification may be relaxed up to class 9. And that is the petitioner, Lordship, qualifying in that case.
In
Lordship.
case there is no such qualified candidate, education qualification may be relaxed up to class 9. The matter of question.
And since this is the reserved for the Muslim community, it is specifically mentioned in advertisement, Lordship, that should be followed.
Now, because of this clause 5, he has a better standing.
Yes, Lordship, I have to bring my stand on by way of affidavit, Lordship. Kindly grant 2 weeks' time, Lordship.
Here, Lordship.
Who is working?
Yes, Lordship.
Who is working? Presently, who is working?
My instruction, Lordship.
Okay, heard MS N.
M. Nirula.
M. Nirolan, counsel for the petitioner. Next para. MS. Next para. Although the matter perhaps appears to be very simple in nature as regards the selection of the selection and appointment of what?
Anganwadi helper, Lordship.
Anganwadi helper in terms of the advertisement dated 0802/2019, MS
S. Borua.
S. Borua, Learned State Council.
Yes, Lordship.
No, on the prayer of MS S. Borua, Learned State Council, that she may be granted sometime to file affidavit the opposition as she has already received the instruction. Let this matter be listed after 2 weeks. So this stuff on the next day, on or before the next date of listing, MS Bora to file the required affidavit. List accordingly.
May I pray for a date, Lord?
Hmm?
May I pray for a date?
After 2 weeks, let her file.
May I please, Your Lordship?
Yes.
The matter relates to appointment on compassionate ground, Lordship.
Hmm?
Matter relates to appointment on compassionate ground. After the death of the petitioner's father in the year 2013, Lordship, petitioner filed his first representation in the month of February.
Madam, it's all over now. What order you can pass? It's all over now. There's a new these policies has been done away. 2024.
Yes, my lord.
What is your stand?
My lords, we have it written in the affidavit that we do not have any scheme as such to appoint any person on a
Not-
compassionate ground.
Now,
Yes, my lords.
earlier when she applied,
There was none then also, my lord.
there was. This is for what? Which department?
Assam Agriculture University.
Horticulture.
Agriculture University.
Okay, the government policy will not apply.
No, it's an autonomous body, my lords.
Okay.
We never
madam?
had such scheme. Because in fact, he was given an opportunity to appear for exam also. However, he did not qualify.
Then, if the government policy is not applicable to the autonomous university, you can't help it out. So, withdraw, close it.
Your Lordship may dispose it.
Heard Mr. MS,
You, Nanda.
you,
Nanda.
Nanda,
N-A-
learned counsel for the petitioner, and also heard Mr.
S. Sharma.
S. Sharma, Land Standing Council, Assam
Agriculture University.
Agricultural University, as well as
Respondent number 1, expressly required.
G.
C. Bora.
G.
C.
G. Bora, Land State Council, Standing Council for Agriculture Department. Next paragraph. This petition has been instituted for by the petitioner for a direction to the respondent authorities, that is the Assam Agriculture University, to appoint the petitioner in any suitable grade 3 vacant post on compassionate ground commensurating with his educational qualifications, on the ground that is further on the ground that the father of the petitioner was working as fieldman who had died in harness on 18/12/2013. List of next paragraph. It is the case of the petitioner that is late father MD Player Ali. Player Ali.
Pierre Ali, Pierre
Pierre.
Mohammed.
PIA.
PIAR.
Pierre Ali, who was working as fieldman in the under the Assam Agriculture University, Horticultural Research Station, Kahikuchi, Gauhati, had died in harness on 18/12/2013, leaving behind his family without any source of income. List of the petitioner being an unemployed educated youth had applied for filed and had submitted an application for appointment in the said post of fieldman or any other suitable grade 3 post on compassionate ground somewhere in the month of February 2014. List of earlier you have filed affidavit on what? You have filed writ petition earlier, no?
Yes, doctor, we have filed in the year 2015 lordship. It was
Huh?
disposed of
Where
in the
it
year
is?
2019 lordship.
Where it is?
It is annexure number 2 lordship, page 34.
List of when the petitioner, when the case of the petitioner was not considered by the respondent authorities, the writ petitioner approached this court by filing writ petition being WPC 6756 of 2015, which was disposed of on 29/03/2019, directing the
Point number 5 lordship, page
Ah.
35.
directing the petitioner to submit the order along with the copy of the writ petition before the registered Assam Agriculture University for consideration. List of list of the despite receipt of the said order and a writ petition, copy of the writ petition along with all the enclosures as directed by this court, the writ petition. The respondent authorities has not considered the representation, has not considered the case of the petitioner. Mr. Being aggrieved, this writ petition has been instituted again. Mr. Next para. The respondent authorities. Where is that? Where is your affidavit? Affidavit on behalf of 1, 3, and 4.
Yes, my lords, 1, 3, and 4.
By filing the affidavit in opposition. By taking a categorical stand that on verification and consideration of the grievance of the petitioner, or appointment on consistent grounds, same could not be exceeded to, in view of the fact that the Assam Agriculture University has not adopted, has no policy or scheme for compassionate appointment, or no policy of the state has been adopted by the university. List of next para. MS
Nanda.
Nanda, Learned Counsel, initially submitted that the petitioner and the respondent authorities are duty bound to consider the case of the petitioner by applying the policy of the scheme of the state government, however, clearly submits that if the university doesn't have any policy or scheme, it may not be possible to consider the case of the petitioner, as the appointment on competent ground would be based on certain policy of the scheme of the university. Next paragraph. Mr. So-and-so, as thus.
S. Sharma, my lord.
S. Sharma, I'm standing counsel for the Assam Agriculture University. While referring to the affidavit filed by the respondent university, submits that since no scheme, public policy, or appointment on compassionate ground to the compassionate ground, no consideration, the petitioner would not be entitled for claiming any, entitled to claim for any appointment on compassionate grounds. Next paragraph. Upon consideration of submissions of learned counsel to the parties, and also perusal of the materials on record, it is admittedly it is an admitted position that the respondent university does not have any policy or scheme or appointment on compassionate grounds to the deceased employees who had died in harness to the to their dependents. List of needless to observe that the appointment on compassionate grounds cannot be claimed as a matter of right, as it has to be a matter of right, but is only to tide up the financial hardship that has caused to the dependent of the deceased family, the deceased employee who had died in harness. Next paragraph. The basis of the claim would emanate only and only when there is a scheme or policy by the authorities for such, providing for such appointment. Mr. In the present case, as noted above, and as fairly submitted by the Land Council for the parties, there is no policy or scheme of the respondent university for such compassionate appointment to the defendant of the deceased family, deceased employee who had died in harness, nor the policy of the state has been, appears to have been, the policy of the state has been adopted by the respondent university. Mr. Be that as it may, by now in the state of Assam, even such policy has been done away in the year 2024. Mr. Does in no case this court, in no case a consideration for consider in no case in no case, comma, any direction could be give direction to be provided to the respondent authorities to consider the case of the petitioner for appointment of compassionate ground in view of which some of the in view of above writ petition, does it merit consideration, and accordingly same is taken dismissed.
Pleasure.
5 and 6.
That's it.
Lordship, in this matter, item number 5, affidavit has been filed, but item number 6, no affidavit has been received. Lordship.
My lord, probably the affidavit in the other case will cover, because the issue is that, my lord, the petitioner has been placed under suspension and DP has been drawn. And subsequently, he has filed resignation. So now his resignation has not been accepted due to pendency of the DP, my lord. That is the main issue, my lord.
Resignation submitted on,
Because
February-
the pendency or during the pendency of the DP, my lord, resignation cannot be accepted, my lord. As per the service.
that is the thing, but Lordship, resignation was submitted on 19/2/21, and Lordship, the DP has been, suspension was placed on 18/3/21, Lordship. So before that, the petitioner has already submitted his resignation, that has not been accepted
Where
yet.
is the period for consideration? What is the period for consideration of your of the resignation? 3 months.
There's
No, my lord, there is no such,
there's no such
period.
rule, Lordship, period.
but the rule is there that the authority may reject or accept the resignation.
Where is that rule?
My lord, that rule.
Can you take it for disposal?
Lordship, that is the thing. If pleadings are completed, Lordship may fix for disposal, Lordship.
2021
That's Lordship.
is still pending,
Yes, my lord.
still under suspension.
Yes.
The
Or you are
he has
retired.
already submitted resignation, and Lordship, his petitioner is not going to the Lordship. Since he has already been suspended.
Suspended since 2021.
Lordship. And the reason,
Yes, because prior to suspension, my lord, because he has stopped attending duties, my lord. Due to unauthorized absence, my lord, the suspension has been made and DP has been initiated.
So what is the outcome?
Outcome, my lord, in the meantime, they have approached before your lordship, my lord, and regarding the DP status quo order has been passed, my lord.
Okay. So what benefits you are drawing for having that interim order?
Lordship, the petitioner had already submitted his resignation. Lordship,
It's
petitioner.
okay, we have understood. After that,
My lord, the transfer order, my lord, that was set aside by the school. Immediately after 2 days of setting aside of the order, now they try to, my lord, initiate a departmental proceeding against me for not complying the transfer order. And DP has been drawn up. And not only that, they have also, my lord,
before or after?
after, my lord,
After passing of the,
after crossing of the bill.
After quashing of the transfer order, but before that order has been passed by your lordship, my lord, for a long period, the petitioner was unauthorisedly absent, my lord. Because immediately after passing of the transfer order, my lord, there was no any stay order passed by this honorable court, but still the petitioner was unauthorisedly absent from his duty.
ultimately the transfer order was set aside.
Yes, my lord.
Then
Yes.
how could you do that?
16 March, it was set aside, 18 March, they are, my lord, they have drawn, my lord.
No, what he's saying is before that you were unauthorizedly absent.
My lord, that's what, my lord, the transfer.
That is the reason that the departmental proceeding has been drawn.
But that has been drawn after setting aside the, my lord,
That's
transfer.
what I'm saying.
Lordship.
That's why
Nothing remained, my lord, when the main or transfer order itself is been set aside, my lord.
see, Mr. Bora,
Yes, my lord.
you have initiated departmental proceeding for unauthorized absence
Yes.
pursuant to the transfer order.
Yes, my lord.
Then the transfer order has been set aside.
Yes, my lord.
After setting aside transfer order, how can you initiate that?
And that DP
There's
statement
the-
of allegation, your lordship will find at page 73 of the writ petition number 3027, my lord.
Why to read petition?
My lord, in the meantime, I had also submitted my resignation since my representation, my lord, has not been considered for, my lord, withdrawal of the transfer order, my lord. I
Why
have
is the order of order for status quo?
that's one IA, my lord. 101.
So what is the way out?
So my submission is there remain nothing, my lord, when, my lord, transfer order itself is set aside.
Obviously, sir, you will say so.
Lordship, my lord.
And search sheet, your lordship kindly peruse that 73 of the writ petition number 3027, my lord. That is the search, my lord.
3027.
3027, my lord.
Page
Page 73, my lord.
73.
That is the search, my lord.
They have avoided mentioning that order has already been set aside. They have avoided.
This transfer from the Gauhati to Silchar
Yes, my
has
lord.
been set aside.
Set aside.
And that was issued on 6/2/2020, my lord.
Then
You were directed to comply with government order. Whereas principal comes and Silchar Medical College Hospital letter dated 1/3/2021 that you never physically reported at Silchar Medical College and Hospital after the issue of the order of attachment dated so and so. 6/2/2020, my lord. Since then, my lord, the transfer The suspension order was issued on, my lord. 18/3/2021. No?
Where is the court's order? Setting aside the transfer order.
My lord, page 61, my lord. Top, WPC
6/2/2020.
One,
WPC 2455, page 61.
58. Start from 58. Huh?
yes, my lord. It
Start
starts
from
from
61, my lord.
58 or 5 start.
No,
Of the-
1423. 1423.
Yes, my lord. Yes, my lord.
Is this your suspension order is 18 after the court's order?
Yes.
Yes, my lord.
When that has been set aside, you have violated while transferring the, you have violated the statutory rules. Appears to be vindictive in nature. What is this page 68?
Six- 68 is, my lord, challenging that suspension order, my lord.
Order to debar him from private settlements as a result, the imprisonment may remain in place. But he shall have to provide as posting.
Although my lord, it is submitted, my lord, they have rejected my prayer of my lord, resignation. But in fact, order has been passed on 5/4. The order is, my lord, this dated, my lord, 1/4/2021. And the submission of the, my lord, state that my prayer for resignation has been, my lord, rejected at page 72nd paragraph. But in fact, the order of that rejection had been passed on 5/4/2021, which is under challenge in this writ petition.
You hear?
In this 2733. 3027.
You have challenged this
Yes, my lord.
rejection.
That rejection of resignation.
And other one is
Other one is against my withdrawal of the DPC. my lord.
suspension and the withdrawal of the
Suspension, I was not very aggrieved because I have already tendered my resignation. So therefore, the court considering that I am not taking any, my lord, subsistence allowance, etc., non-practicing allowance, and I am willing to forego the subsistence allowance. So those part
But
was.
you
my lord,
appears to be not interested in government job, more of
Yes,
a
yes, I have
you-
tendered my
you are-
resignation. It
You are
cannot.
more
my lord,
interested in private practice.
my lord, no prudent person, my lord, at that
Yeah.
time could have, my lord, walked, my lord, under the state government, my lord, at that time. My lord.
Hmm.
It's all forced. Lordship has seen, my lord, Lordship
And
has
initial allegation
has seen
then only, my lord.
how vindictive,
Because
my lord.
initial allegation was that, my lord, while he was serving as a government doctor, my lord, he was practicing in a private nursing home.
That
and-
was negated.
That was
Your
negated.
departmental proceeding is not on
No,
that.
my lord, that part has not been negated.
Yes,
Because
yes.
there was allegation.
No, your department proceedings is not on that ground.
Not
not
on
on
that.
There is
ground.
not the charges.
Yes, my lord. The
You are only
charges-
the unauthorized absence.
Yes, my lord.
That to pursuant to the transfer order,
Yes, my lord.
which this court finds to be not in concurrence, in
Yes,
violation of
yes, my
statute.
lord. But, because the concern of the department is that, my lord, because if the doctors, government doctors, they continue their private practice and they kept on sending the patients to their private place of practice, my lord, then obviously government institute is getting affected. That was a basic concern, my lord. And subsequently, my lord, when he was transferred, he tendered his resignation.
My
my
lord,
lord.
this allegation has been considered in the in the order, my lord, by which the transfer order was set aside. This allegation has been considered and found, my lord, it is vindictive, my lord. No inquiry, nothing. My lord, this same day 6/2 the allegation comes and 6/2, my lord, I have been, my lord, transferred to my lord, the Silchar. That too in a department of, my lord, ENT, whereas I am working in oncology. Then on attachment, the code, my lord, categorical finding, my lord, that cannot be transferred, my lord, because the department of a college itself constitute a cadre, my lord.
So initially you have to first cross the hurdles of this departmental proceedings. Then only your consideration for
Yes, my lord.
That's what they say, my
whether
lord.
rightly or wrongly this has been rejected. Because they may reject your prayer also.
My lord, my lord, that is again, my lord,
But I think, Mr. Bora, the basis of initiation of this proceeding is not, cannot be a basis once this court has held that your transfer order was in violation of the statutory rules. Although in that proceeding
But my
you
lord,
tried
when
you made an attempt to the extent that he had some other, I mean,
My lord, apart from that,
committed
when
some-
it was held by this honorable court, my lord, assuming that from that day, my lord, it is passed. But prior to that, my lord,
No, once that order
yes, my lord,
pursuant to which you are alleging
yes.
unauthorized absence,
Yes.
it goes, everything goes along with that.
But apparently, my lord, for that period, my lord, when this honorable court has passed that order, my lord, from that day, my lord, it is okay, my lord. That cannot be sustained, my lord. But till that date, my
But
lord,
that's the same thing, from that order has been set aside,
yes, my lord,
finally,
yes, my lord,
pursuant to which you are alleging unauthorized absence.
yes, my lord.
Better ends there.
But
You cannot allege
how
that.
that period will be counted, my lord? How that period will be treated? From the date of passing of the transfer order till
Yes.
the order passed by this honorable
is
court, he
deemed-
was not attending
deemed to-
duties, my lord.
Huh?
He was not attending duties anywhere, my lord.
You have not said so.
My lord, that is the issue.
You had
my lord.
heard and
That's
that
why I
order
said.
was, so once the order is gone, matter ends there. It goes along everything. It takes within it sweeps everything. Whether Silchar, Guwahati, wherever. You cannot have you could not have initiated proceedings on that. Writ petition allowed. What do you say?
Yes, my lord. Your lordship, my lord. I
You want to make more submission?
No, my lord. I am just placing the facts, my lord. It's up to you.
That's okay, I understood. This is the main one.
2455 regarding that disciplinary proceeding.
No, no. Or to put-
Initiation of disciplinary proceeding and
This is 207 is?
2078 regarding rejection of the, my lord, resignation.
Resignation.
Okay, so then in that case, we'll have to consider this first. Then only rejection will come. Right. Okay, can we dispose it of?
Yes, my lord. Lovely.
Heard Mr. P.J. Shekhar, Learned Senior Counsel assisted by M.S. M. Nirol, Learned Counsel for the petitioner. And also heard Mr. D.P. Bora,
Yes.
Learned Standing Counsel, Health and Family Welfare Department. Dispose of. I'll see.
Lovely.
Item 10.
Yes.
Lordship, this matter pertains to Lordship promotion to the post of Anganwadi worker from Anganwadi helper who has completed more than 10 years of service
Hmm.
and as per the guidelines, Lordship.
Hmm.
The petitioner, Lordship, she was appointed on 23/12/2009, Lordship, as Anganwadi helper in 233 number Umulipara Anganwadi Center.
They're ready.
Otherwise, my lord, we have filed affidavit ready, my lord.
Okay.
My humble
After-
submission for lordship, my lord.
After filing of the affidavit in reply,
I reply here.
they took time to bring the records,
What?
the original records, because in my affidavit reply, after filing of the affidavit in opposition, which they have one,
You tell us your case,
yes.
then we'll go to.
No, my lord, first of all, preliminary objection is that, my lord.
Huh?
Who seeks justice, he comes with a clean hands. Lordship, kindly see advertisement.
No, sir.
No, but there's a.
Sir, I have not heard him. So I said, I request him to proceed. Let us hear his case.
Yes, yes.
Then I'll come back to you.
Yes, yes, lordship.
Yes. Can be disposed of without records also?
Yes, can be.
Who is for
In this case,
any other person?
Lordship, the records,
Private respondent is there.
private respondent is there.
You are there. Who is 7? Who has been appointed?
No, no,
Ah.
he only been recommended, not appointed.
I may be allowed to file affidavit in opposition. I have voluntarily filed a wakalatnama. Notice was not served to me, lordship. I don't.
Voluntarily?
Voluntarily filed wakalatnama.
How can you file a wakalatna voluntarily?
On behalf of respondent.
It's defeating the meaning of wakalatnama.
Notice was not sent to me, lordship. Can you give the first order, lordship?
Hmm.
For respondent number 7, notice was not served, lordship. So I don't have the petition copy, lordship.
Hmm.
I will file a 2 weeks time, lordship, may grant. I feel.
Her name, he or she?
See.
Her name has been recommended.
Recommended, but
Nobody has been
no one
appointed.
has been promoted also.
A promoter, huh?
January 2026. I'm something.
You're working.
No, that is a wrong submission. Lordship. No one has been prompted.
Application opposition, Lordship.
You have the appointment order.
I have.
Just wait. Just keep. You just tell us why. You have, there are three conditions
Lordship.
for promotion. One is completes 10 years as Anganwadi helper.
Lordship. Minimum qualification is class 9 pass, and Lordship, the age should not exceed 45 years. This qualification, Lordship, we both does not have, Lordship.
Class 9 passed and should not exceed 45 years.
Lordship.
So what is your qualification?
Lordship, my qualification is high secondary, Lordship.
You are class 10 passed?
No, high secondary, Lordship.
No. Minimum is 9. So you are
Minimum is-
eligible. You have
minimum
the
is-
education qualification. Then 10 years you have.
10 years, Lordship.
What about 45 years?
45 years, both don't have, Lordship.
Huh?
Lordship, but I am much,
Forget about this.
Yes.
There are three
three
qualifications.
qualifications required, Lordship.
One is 10 years
10 years,
as an Anganwadi worker,
Lordship.
a helper, sorry.
Helper,
Then
Class
second
nine.
is
class 9
class 9
minimum.
pass.
And
You
then, Lordship,
fulfill whatever,
minimum age
should not exceed 45 years.
Lordship.
You exceed 45 years.
No.
Then
Age-
come to advertisement. Where is it? Advertisement.
Yes, Lordship. Page annexure 7, page 28, Lordship.
28. This is translated.
Translated, Lordship.
Ah.
As per memo number so and so, there are
Will
certain
apply
vacant
be
posts,
at
right?
the resident of particular area of respective and other regular from difference and it cannot apply. No issue.
Lordship.
Both parties, no
Both
issue.
don't have any
Number
issue.
one. Then number two, 10 years,
10 years, Lordship.
both
Lordship.
10 years
Both.
then
Now,
must
Lordship,
be as it up to 40 years old. You have written wrongly. You said it must not exceed 45 years.
Lordship.
You must be 45 years
45 years, Lordship. That,
on 1st
Lordship,
January
that-
2021.
Yes. That qualification we both don't.
What is your age?
So my age is the Lordship,
22.
36 in the year 2023.
Huh?
In the year 2023, I was 36.
36.
36.
Now,
Now it would be 39.
even not 45. Goes. Then what about her age?
He is younger than me, Lordship. She is younger than me, Lordship.
Then why?
Lordship, my first appointment was 13/7/2007.
No, age.
No, age.
Age.
In age and.
You are also class 10 pass, class 9 pass, and you have also worked for 10 years.
He is senior in age, Lordship, not in work, Lordship.
No, not work. Have you completed 10 years as a Anganwadi helper? Huh?
2007, I got first appointment, Lordship. He got in 2009, Lordship. In
Then what about your age?
30, on 2007, I was 34 years old.
Then
Lordship, I got
in 2021, what is your age?
everything filed and.
Yes, Mr.
Yes.
Sitye.
Lordship, kindly see page 28 regarding the advertisement.
Yes.
I am pointing out it, my lord.
Yes.
Kindly see serial number 3.
Hmm.
The Anganwadi helper must be aged up to 45 years age on. It is wrong translation. It is within 45 years. It should be within 45 years. I have seen the Assamese version.
Okay.
And also, he has not completely translated into English the Assamese version of the advertisement. That's why some points are concealed by him. On the on
So
the
the Assamese version,
yes,
what does it say?
Page 29.
Ah.
There is something more.
I don't know.
Yes, that's why, my lord, that's why it is on this ground alone, my lord, this prohibition should be dismissed. I am pointing out page 30. That is the point, serial number 9 in Assamese version, my lord. সরকারি নীতি নিৰ্দেশনা অনুসৰি মৌখিক সাক্ষাৎকাৰ ভিত্তিত সহায়িকাসকলক নিৰ্বাচিত কৰা হ'ব. Why this point is not mentioned? Because
What is that say?
it says the selection will be made on on the basis of vibrancy of the candidates. That point is not given. Why the petitioner is considering this point, my lord?
On the basis of
Yes, how they
vibrancy.
should be selected, that is not translated.
No. What about this serial number 4?
9.
And serial number 3?
Serial number
Anganwadi helper
3
must
is
be.
only those Anganwadi helpers shall be eligible for apply under the scheme who have been in continuous service for a period of 10 years. Okay, it is okay. But third is the Anganwadi helper must be aged up to 45 years, does not meaning the actual meaning of the Malot Assamese version. Assamese version is the Anganwadi helper must be within the age of 45 years. Within. That is forgetting. Anyhow, they are not crossing it. The required qualification for the post of minimum in class 9. So petitioner and respondent, they have got the qualification for qualified to the post of Anganwadi helper. They are qualified. And now this version is not translated. That's why not even.
Okay, vibrancy will come later.
Yes.
But what about this? Serial number 3?
How lordship will develop?
Serial number 3?
Yes, because these points are not translated.
No. Serial number 3 is what? Is
Serial
it the
number
correct translation or not?
Yeah, that is required qualification for the minimum 10. The applicant should extend annex a copy of the mark sheet along with the application.
Sir, and I am on serial number 3. It
Yes,
said
yes,
Anganwadi helper must be aged up to 45 years.
Yes.
Is it correct translation?
Yes, I am reading it. আবেদন কৰা সহায়িকাসকলৰ বয়স 2021 চনৰ 1 জুনৰ 45 বছৰ ভিতৰত হ'ব লাগিব. That means on 1st January 2021, their age should be within 45 years. Detail number 3.
It doesn't say, it's also not correct translation.
He has acted under 25. That means who has attained the age of 45 years eligible.
Up to the age of 45, this is a correct answer. Anganwadi helper must be aged up to 45 years.
What?
That is within the 45 years.
Normal, it is not the meaning.
Correct
The
answer.
Anganwadi helper must be aged up to 45 years. What does it mean? The meaning should be they must be within the age of 45 years.
That is the meaning, the translation.
It is not meaning like that.
Lordship, may kindly.
However, my lord, page 30,
Lordship,
the
may
serial
allow
number
me to-
9. Let me submit, my lord. This advertisement is not totally translated to the English. Lordship, how Lordship will come to the conclusion to what is the condition of selection of the candidates that was suppressed. Serial number 9, সরকারি নীতি নির্দেশনা অনুসৰি মৌখিক সাক্ষাৎকাৰ ভিত্তিত, that means viva on the basis of vibrancy, selection of the candidates will be done. That is the ballot as per government guidelines. As per Assam government guidelines, the selection will be made on the basis of viva interview only. That was why suppress it. That's why we have filed affidavit. Our affidavit, we have tell Lordship kindly take up the affidavit filed by us. Respondent number 2. Additional diagram. Paragraph Lordship kindly see paragraph 5. Before the best to state the petitioner and respondent number 7 have completed 10 years of experience as Anganwadi helper. The respondent number 7, the Poida Begum, is senior to the petitioner, and she has passed SSLC examination as per guideline for the selection of candidates for the post of Anganwadi worker. The main criteria is seniority cum merit and having minimum 10 years continuous service as Anganwadi helper. According to the respondent number 7 has been selected, having found all requisite norms. That is the ballot our stand. Lordship kindly sees the select list. Page 52. 11th portion ballot. Kindly see serial number 3. The petitioner Rochana Ahmed, higher secondary pass, 40% marks, 34 years, and 10 years mark is good. Has you also got it? Good. And respondent number 7, serial number 5, Poida Begum. She is SSLC pass, 36%, 34 years, general, 10 years as Anganwadi helper, excellent. So the selection body has marked good, average, and excellent. Actually, normally these three words are there: good, average, and excellent. Here, petitioner is found good, but the response number 7 is found excellent. So this
Selection committee was there.
this is about selection comparative statement of the selection committee. So these are not challenged by the petitioner.
Lordship, in my reply, Lordship, case 59, Lordship, paragraph 4. Case 59, Lordship, paragraph 4. Lordship, may I read, Lordship, small paragraph. That with regard to the statement made in paragraph 4 of the affidavit in opposition, the answering representative strongly opposes the same. From the affidavit in opposition, it is now clear that the entire selection process was a farce because of apparent illegalities. The actual merit of the candidate was not properly assessed by the selection committee, and there was a serious fraud by selection committee, which will be evident.
Page?
Page 59, Lordship.
59.
Page 59 of my affidavit reply, Lordship. Now, Lordship, come to page 60, Lordship. I have given that ABCD, Lordship. Firstly, Lordship, the comparative cert enclosed with the affidavit in opposition has no specific dates and therefore has no evidentiary value. Undated documents lack legal validity and evidentiary value, often deemed unenforceable in court. Without a date, establishing the authenticity, timing, and legal rights of a document is difficult, causing courts to reject them as primary evidence. Such documents may be considered dumb documents or invalid. Secondly, the third member of the selection committee is shown to be of one Tamsun Nessa. MSG member was never a part of the selection committee, nor she was present during the oral interview. It is really surprising when and how she was made a member of the selection committee. Selection committee minus if called for will reveal the same. Further, obtaining a signature from the said lady member who was not even present during the entire oral interview is a serious foul play, which has vitiated the entire selection. Lordship, on the last occasion after coming to this, Lordship, my reply, they took time to file an additional affidavit and to bring the minutes on record. That has not been done. Thirdly, despite the petitioner having secured highest percentage of marks in the qualifying examination, HSLC 44.6 and high secondary 36.25, the private respondent number 7, who has secured only 36% in SSLC, has been favored. But surprisingly, petitioner has been shown to have secured 40% in SS. So the selection committee has not even able to do the minimum task of correct calculation of the marks of the qualifying examination. Whether they have done the correct calculation of the percentage of marks of the qualifying examination of other candidates is a serious doubt. The selection committee has not followed the guidelines properly, and biasness in selecting the candidate cannot be ruled out. Records of the selection, if called for, will prove the same. Fourthly, Lordship, another illegality has come out from the comparative cert that running hand signature shown to be of CDPO Binarani Devi does not belong to her because she always puts initial signature in all the official documents, and this cannot be an exception. If a specimen signature is collected from her and sent to forensic for comparison to of both the signatures, the actual truth will come out. And I have given a Lordship official document signed by Binarani Devi at Annexure A, which does not tally with Lordship the signature put in the comparative statement.
Then why you have not mentioned on 17/7/2026?
Lordship.
You said it is evident the pleadings in matter, complaint matter be taken up final consideration.
Lordship. Because no one was there at Lordship, that court was in a hurry, Lordship, just fix the matter for hearing.
You are blaming the court.
No.
Then?
My learned friend was also not there initially.
Then how it is
private respondent.
How it is recorded?
Private respondent was not there when the matter was called.
Then how it was recorded?
Then at 4:30 during rising of the time, Lordship, he appeared. Lordship can.
Heard Mr. S.K. Das, learned counsel for the petitioner. Unnecessary we have spent time.
That is why Lordship, initially I thought that Lordship the records were necessary.
And also heard Mr. Learned
For
State Council for
1, 2, and 3.
1, 2, and 3, as well as Mr. Yes, I am learned counsel for the respondent.
And
Next
4, 5, and 6, whether
After hearing the
or not, I don't know.
matter at some length, Mr. S.K. Das, learned counsel for the petitioner, points out that submits that in view of the affidavit in reply filed by the petitioner, this court filed an order that 23/03/2026. No. Before that. Order 1702/2026 directed the government advocate to file additional affidavit to bring on record the minutes of the meeting and the guidelines. However, same is yet to be filed by the government advocate. Next paragraph. Considering the issue involved in the matter, let this matter be listed after. No, because involved, I'm of the considered bidder. And as evidential affidavit is directed to be filed by Tisco on 17/02/2026. Be filed on or before the next date of listing. Next para. It is also noticed that the petitioner has not properly translated the advertisement. Therefore, he is also therefore the learned counsel for the petitioner is also directed to file the properly translated copy of the advertisement. Next para is and it is also directed the respondent number 7 to file her affidavit. This after 3 weeks.
Lordship, may kindly give a fixed date, Lordship.
You also file
The proper translation of the
translated
advertisement,
copy of
Yes,
the and then additional affidavit already directed twice
Yes.
to the government advocate and you also. You serve the copy. Give it back. I don't know what is the appointment letter or no.
Lordship, when the matter is in session, Lordship, they cannot give appointment, Lordship.
I don't know. It's in Assamese vernacular. So I don't know whether it's an
Lordship.
appointment order or not.
Lordship,
Okay,
Lordship.
next.
Since I will give him a writ petition copy, he may be given the appointment order, Lordship.
Item 11.
My lord, that pertains to dismissal from service. It's basically a case of a solitary instance of indiscipline, which we otherwise have admitted, my lord. He was, my lord, off duty after rendering duty for the whole day. Then in the evening, when he was off duty, my lord, he had consumed some alcohol, admittedly. But then he was at that point of time again detained immediately for duty for some ambush operation. He initially said that I have consumed alcohol, so let me not go. On that issue, my lord, there was some altercation with the senior, which led to the dismissal of.
Senior was a lady.
No, not a lady.
Senior was a lady.
No,
officer.
not a lady, my lord. But then the matter was in fact heard at some length on the last occasion. The actual proceeding.
That record will be necessary, Lordship.
You don't have the record.
Today I don't have. Last occasion it was.
In fact, I have also, as per the last order, gone through the record. The record is basically in Hindi vernacular, my lord. So I would place the translated, my lord, copies of the same, my lord, so that it is easier for the court also to, my lord, appreciate.
Hindi.
It is in Hindi.
It's in Hindi.
My lord.
I'm comfortable with the Hindi.
But then filing will not accept it, no, my lord. I understand lordship is comfortable, but then filing will not accept it in Hindi.
Not that grammatically.
My lord.
And not the tone also.
My
But
lord.
then I can understand. Okay. Then when?
After 3 weeks, my lord.
And Mr. B. Patel, learned counsel for the petitioner. And also. And Mr. B. Chakraborty. Learned standing, learned CGC for the respondent. As spread for by parties, let this matter be listed after 3 weeks. In the meantime, what you will file?
My lord, the records of the, my lord, proceedings, my lord.
Records of the proceedings may be filed by translating from what do you call it? Translating the same from Hindi to English.
My lord.
You have to produce You need to
I'll
produce the
produce-
record.
On next date, I'll produce.
Otherwise, the original
CJC.
may be also.
CJC is also directed to. Then CJC also to produce the record. Yes, next.
Well,
May I please, Lordship, kindly pass over the matter for time being, Lordship. Concerns CBC legs in another court.
What is to be done today?
Yes, Lordship.
My lord, it was fixed otherwise for admission hearing.
Is it
Small issue, my lord.
can be disposed of? If not, some other day. If it can be disposed of, it's okay, we'll hear you.
My lord, can we dispose of, my lord? In fact, my case has become weaker because it is a case of, my lord, reinstatement. And he's almost, otherwise, my lord, his age is approaching 60. So there's hardly any point of actually reinstatement as of.
So you don't have a case much.
In that sense, my lord, it has become weak, my lord.
Huh?
In that sense, it has become a weak case for reinstatement.
Then we'll be dismissing it.
After recording my submission, after recording my submission.
Mr. B. Pathak, Land Council, but is also on MS.
As for
As Borough understand that this matter will be listed
Arkadev Chaudhary,
as spread for Arkadev Chaudhary, learned DSJ. Let this matter, as spread for by the party, let this matter listed after 3 weeks. 2 weeks.
2 weeks.
If it is for dismissal, but not interested.
13.
In this
Yes,
case, no-
sir.
no affidavit has been filed, my lord.
I appeal for BTC. We have received Paraguay's comments, Lordship will permit me 3 weeks.
What is the matter about?
Matter about non-payment of, my lord, pension, my lord.
Why you are not paying?
Lordship, there is a discrepancy in his date of birth between the service book and the government records.
Who has to correct it?
My lord, to
Who
the
has to correct it?
government, my lord.
Who is the government?
Lordship,
BTC.
BTC has recorded the fact that there is an error. So that process as to which will be considered the correct date, that Lordship, we have received instructions. Lordship will allow me to place it on affidavit.
No, that's what I'm saying. What is to be done is a payment of pension only. If it is to be only for correction, why taking time? Do it.
Yes, Lordship, we will do it.
You'll correct it.
Lordship, no, so the issue is that according to us, the correct date is the correct date of birth is 8/1/1916. And I think perhaps my learned friend is saying that it should be 8/1.
You retired age?
Now retired, my lord.
Retired age what?
As my lord, helper, my lord.
Helper.
Yes.
Lord, grade 4 employee, my lord.
So you have submitted before the executive engineer.
My lord,
So
pension
he has
proposal
not, he has not provided.
my lord. And now, my lord, pension paper are pending before the, my lord, respondent number 1, my lord.
Which one?
Litigation department.
Huh?
Respondent number 1, Commissioner Secretary, my lord.
Yes.
ICC page 49, my lord.
No, if it is not, if the records are to be corrected, then how can they forward it? Who has to correct it?
Lordship, perhaps the respondent number 1.
Lordship, it has to come from the Lordship, the
Yes.
proposal has to come from him, the
Yes.
executive engineer, Lordship, there is a requirement of correction.
If there is a hurdle on our part as far as that particular date is concerned. So Lordship will allow me to place that on affidavit. Lordship will then
Saying what?
saying that Lordship, the correct date according to us is 8/1/1916.
Hmm.
And it has not proceeded only because the discrepancy is there. Because of that, we have not been able to issue that proposal.
So what you are proposing to do?
If
No.
Lordship directs, we will then
Are you trying to, are you going to correct as per his version, or are you going to have?
no, our version.
Okay, heard Mr. K.R. Pathak, Land Council for the petitioner. The man has already died.
Already subsequently during pendency of the writ petition died, my lord. I have substituted, my lord.
Lordship will permit me last opportunity, 2 weeks will find positive.
As prayed for by Mr. Mr. S.C.
A. Atria, Lordship.
A. Atria,
Atria.
Learned Standing Council, BTC. 2 weeks' time is granted to file affidavit in opposition. It is made clear that respondents to file the affidavit on or before the next date as the matter pertains to claim of pension Achha.
Okay.
I am appearing for 1 and 4 also. Anupati.
Yes, Mr. N. Learned Standing Council,
Lots of
Irrigation and
1 and 4.
Irrigation Department is present. You also.
I also take instruction. I also.
In that case, are present. Yes.
Oblige.
Item 16.
Hey, Lordship, the petitioner was imposed penalty after departmental proceedings, stopping one increment. Because petitioner, he maintained 2 files to give a information to the health department regarding age of a employee. Once he have given his actual age, thereafter after 6
Where is the
months,
petitioner?
petitioner is not there, my lord.
Okay, non-appearance petition.
Oh, right. The earlier occasion also, my lord. Time. Urban? Yes. Urban, I guess. I'll go around.
So Lordship, this is the petition challenging the impugned order. That is Lordship, that is impugned order page 28. Lordship, whereby withheld my increment.
After disciplinary proceedings?
Yeah. Yes, Lordship.
After disciplinary proceedings?
yeah.
Do you have the records?
No, my lord.
What is the challenge
We
here?
have file affidavit. We have.
It's okay. On what ground?
Lordship, I have been asked to prepare a age verification report. So
That is on merit.
merit.
What's wrong in the disciplinary proceedings?
Lordship, that verification report has.
It's okay. It's on merit. What you are alleging? What's wrong in the proceedings?
The proceeding, Lordship.
First, we'll have to
wrong-
see that.
wrong with
Merit
the-
will come.
Lordship, wrong with the order is that the age verification report has came.
Again, you are coming back to the merit. What's wrong in the proceeding? Is there any violation of the
Yes, Lordship.
procedure?
Yes,
What is the violation?
it is a total case of discrimination, Lordships.
What discrimination?
Yes, Lordships. Because 3 persons are collectively responsible if something wrong with the age verification report.
Have you taken that ground
Yes, Lordship.
in your written statement?
Yeah.
Are you sure?
And
So us.
it is in my Lordship, that is in reply affidavit filed by the respondent number 2.
Reply affidavit? Your written is submission, written statement.
Yeah.
In
That is my-
the proceeding.
Affidavit.
Yes, Mr. Just call the Jabara. 5 minutes. We'll resume after 5 minutes.
Yes, sir. Okay.
That's me.
এটা শোকজ আছে নাকি এখনো অ্যারেস্ট করিয়ে দেয় শোকজ করে অ্যারেস্ট করিয়ে দেয় Yes.
It is the reply to the so cause notice, Lordship. Page 16, Lordship.
I think it's there to complete so cause reply, my lord. So far, my petition is concerned, my lord. Page 16. It is? What?
Ah, 16. Our page 9.
It is, there is no signature at all, my lord.
The incomplete, Lordships.
And so cause notice is not, no, I think, my lord, what happened, my lord, in Republic of Proceed, there is no,
Lordship,
my
it
lord,
is incomplete
no
possession.
violation of any norms, and for a decision making process, there is, my lord, they have followed all these things. They have passed so cause notice issued, he replied it, not satisfied, then draw the departmental proceeding. Thereafter, after inquiry, my lord, inquiry report was submitted to him with a second so cause. And thereafter, penalty imposed. So what is wrong?
No, that's why I'm asking. What's wrong in the departmental proceedings?
Nothing.
Is there any violation of the procedure, rules? Then you said there's some other person also. You said that you have been discriminated.
Yes,
How?
Lordship. How it is, Lordship? This age verification report has came through two competent verifying officers. Next competent officer is registrar and final competent officer is deputy secretary. So there would have been something wrong in the age verification report. The two competent officers could have been finding out. 3%, they have the custodial responsibility, Lordships.
Well, you have said so.
One thing, my lord, Lordship, kindly see page 29. His appeal, my lord, after passing imposing penalty, there is a provision for appeal, my lord, against the order of secretary. So, impugned order passed by the secretary, against this, he petitioner file an appeal. Page 29. This appeal is wrong. He addressed to the Commissioner Secretary Education Department. Appeal is lie to the chairman of the board. So that's why, my lord, it's wrong. That's why, my lord, Lordship may dispose of the matter, directing him to file an appeal properly. Because as per rules, my lord, rules is against the order of secretary, he should go to the chairman for appeal. Then it is, my lord, then it left one option to the government. Now it is, my lord, premature. Appellate authority, Lordship, penalty D. Appellate authority means one, the chairman of the board in respect of an appeal preferred against any order passed by the secretary, and board in respect of the appeal preferred against the order passed issued by the chairman.
What is the impugned order? Passed by the?
Passed by the secretary, Lordship, can you see page 28.
28, Lordship.
Then?
Page 28, Lordship.
28. This is an order. The pursuance of the inquiry report conducted by so-and-so, director of so-and-so, on a LS age verification report of candidate Samsun Haq Barbhuia bearing rule number so-and-so, it is established that say Hemanto Kolita, the petitioner, was associated with the offense of the concealing facts and breach of the trust in discharging his duties. Hence, as per provision of the Assam Secretary Discipline and Appeal Rules 1964, one annual increment due for his 2021 in respect of Hemanto Kolita will be withheld with the cumulative effect, and he is reinstated in his original post with effect from the date of joining. Against this order, he can file an appeal before the chairman, not for the commissioner secretary.
Commissioner secretary is different.
No, chairman.
No, that's it. Commissioner secretary is different. Commissioner is different from chairman.
Yeah, different.
Lordship, Commissioner Secretary is the appellate authority.
Where it is?
Let him show, my lord.
This is what rule?
Lordship,
Move to order.
Lordship, if something wrong with the procedural laws, procedure, inadvertence or mistake something there, for that, whatever the substantial right I have, that cannot deny. Maybe.
But you have to approach the proper
Lordship,
authority.
procedural mistakes may be there. It is active.
See, before that, if you don't agree, what is the procedural lapses while conducting or discipline proceedings? What has been violated in the procedure?
Lordship, procedure, whatever procedure has taken, and step by step we have.
You have participated.
I have replied it.
You have replied it.
Yes.
You have been participated. Was there any evidence taken?
That is the reply of so cause my.
Ah.
That is there.
Thereafter, there was an inquiry where you have participated. You have participated.
Yes, but
What is the violation of any procedure? See, for a discipline to
Lordship, violation in the procedure
is what?
as they have taken, no, Lordship, as they have taken the plea right now, that there is the instead of appeal filed before the chairman, I have filed it before the commissioner secretary. Lordship, my point is that.
Okay, let us determine your case, the merit on the writ petition. Forget for a timing, let us forget the appeal provision.
Yes.
What's wrong there? What's wrong here in the discipline proceedings? You tell us.
Yes, that is the wrong something, because Lordship, there are 3 persons involved.
Where you have said?
Here it is.
Page 16 doesn't say anything. Simply you have said,
Some here.
as per the certificate,
Lordship,
then the higher authorities has accepted it. That's all.
Lordship, page 16.
What is the wrong in disciplinary proceeding? Tell us. We have a very limited scope so far as the disciplinary proceedings is concerned.
Disciplinary proceedings should be, Lordship should be equally.
Where we get?
Because other
Where is your reply?
2 competent officers.
Where is your written statement?
Lordship, what
Reply.
Why the other 2 competent officers, those are responsibility is there in verify, in preparation.
See, after conclusion,
why they have exempted?
Have you said so during the proceedings?
Lordship, why they have exempted?
Why did you say so during proceedings?
Disciplinary action should be equal under Article 14. It is total violation of under Article 14.
Sir, I am asking whether you have taken the stand when at the time of disciplinary proceedings, by a written statement or by statement, anything. Have you taken that?
I have given so far reply. That was there, Lordship.
Page 16, you read page 16. What does it say?
Actually, there is some pages lapses, Lordship. It is incomplete.
What can I do?
Please.
It's your writ petition. See, let us be very clear. Let us understand the law. So far as the challenge to the discipline proceedings or the penalty is concerned,
Lordship.
first of they were basically the writ court will determine, see whether there is a procedural lapses or the rules or the procedure has been properly followed or not. Is there any violation of your right?
Lordship,
So far as
Lordship, proceeding has taken properly.
then
But order.
matter ends there. Writ petition dismissed.
Lordship, whatever the order passed, it is total discriminatory. My point is that why?
See, after conclusion, you cannot take all these things. We don't know. That's why I just ask you to show any statement by you, even in your evidence or even your reply or the written statement. You show us that you have taken this and you have they have not considered that.
Lordship, one more chance. I will place it because some parts of this lapses somewhere.
So it is a vexatious petition, Lordship policy. I am pointing one thing. Page 9. Prayer.
He may not have ground, but then it's not vexatious. Sir, it's not vexatious.
He is seeking mandamus. Directive should not be issued. Directive responsible to consider the disposal of the appeal. Respondent number 2 is the secretary who
Yes.
passed the impeach order.
Yeah, there may be mistake, but then
But it is vexatious petition, my lord.
it cannot be, sir, it cannot be called a vexatious, it's too harsh. Too harsh in word.
What he is paying? His payer is this.
Prayer is.
Or
to
else
set up
you file an appeal. We'll give you a liberty. You file the affidavit because it's a dissensory appeal,
Yeah, that's.
you have to avail that. You
Okay,
withdraw and we'll give you a liberty to file
That's it,
appeal
I will
before the
file-
appropriate authority.
If something wrong with the filing the appeal, please give me one more chance. I will file the appeal before the council.
Heard, Mr.
B. Kalita. That's it.
B. Kalita. P.
P. Kalita.
P. Kalita, learned counsel by the petitioner. After submission, submits the, no, Mr. P. Kalita, learned counsel for the petitioner. After arguing the matter at some length and having realized that the appeal, the statutory appeal filed by the petitioner is addressed to, is before the Commissioner Secretary of Education, Assam, Gauhati, Assam, who is not an appropriate appellate authority in view of the, what is this regulation?
Regulation. Yeah, regulation.
In view of,
Assam State School Education
in view of the
Regulation Board.
Assam
Assam
State School Education
Board.
Board Regulation, 2024. When did you file this appeal?
Yes, D, number D.
When did you file your appeal? On when?
Appeal required against the impugned order of justice. That's it, secretary.
When
No
did
date,
you
madam.
file?
No date. And also it is not properly.
Which provides the appellate authority as the chairman of the board, press for withdrawal of this writ petition with a liberty to file an appeal against the order dated 16/11/2021 passed by the Secretary Board of Secondary Education, Assam, before the chairman of the board in terms of the regulation, aforesaid regulation. Please, Mr. T.C. Chutia, London State Council, as well as Mr. Who else are appearing?
DK Roy.
D.K. Roy, London. You are also appearing.
For school number 1.
Standing Council, Assam?
D.K. Roy, madam.
Assam? Standing Council, Assam?
Assam State School Education.
Assam State
School Education.
School Education Board.
Department of School Education, Secondary Department.
And
School number 1.
so and so are present. In view of the submission of, considering the submissions of London Council for the petition, our district petition is closed with a liberty to the petitioner to avail the appropriate, to file appeal. Appeal as spread for against the order dated 16/11/2021.
That's it.
Obliged.
I took 70.
Return this.
Well, in this case, the petitioner, after passing through the selection procedure, he successfully completed all the stages of the interview method, but subsequently, his name was not been figured in the final merit list. And then he filed this writ petition, but recently, the respondents have filed an affidavit by saying that the cutoff marks has subsequently been normalized. And after normalization of the marks, the petitioner got the less marks than the last candidate who have selected, my lord. But now, my lord, I like to file the reply because of the fact
Or
that
Mr. On the prayer of Mr. No, Mr.
R. Islam, my lord.
R. Islam, learned counsel for the petitioner. Praise for and is granted 3 weeks time to file affidavit in reply.
Yes,
List
much
after 3 weeks.
Sir, the non-payment of family pension, your lordship.
Yes. Then,
Lordship, we have received otherwise comments. We'll file
or
that.
Mr.
A. Rahman. A. Rahman.
A. Rahman, learned counsel for the petitioner.
My lord,
On the prayer of Mr.
Yeah, yeah, Lordship.
A. Learned standing counsel, BTC.
BTC, Lordship. BTC.
my lord, your lordship can dispose of the matter. My lord. I think my learned friend will not oppose. Directing.
Then this
Lordship,
matter
we
be
have to
listed after 3 weeks so as to enable Mr. Atria, learned counsel, learned standing counsel to file affidavit in opposition. Yes.
My lord, okay. Date may be fixed, your lordship.
3 weeks.
After 3 weeks.
3 weeks. We are here, Mr. You are around. 3 weeks.
My lord.
Okay.
20.
Lordship, in this, we have filed an affidavit last week.
So
Lordship, I need.
you have received it.
No, your lordship, I haven't received the hard
We
copy.
filed for physical copy.
Okay. Although Mr.
Yeah.
A. Atria, learned standing counsel BTC submits that an affidavit in opposition of the respondent BTC has been filed. Same is not the same is not available in the record. List of registry to verify it. The same, and if it is filed, take with the record. Mr. The learned counsel for the petitioner be served with the copy of the affidavit in office.
Copy.
21.
Lordship, in the matter as per order dated 1/4/26,
Yes.
Lordship, this court has instructed us to file a compliance report. Lordship, we have not received the report from the concerned department. Lordship, some time may be given to get the same.
What does it, what it is, it says, be sent to be withdrawn from meeting the needs of the.
$15 lakhs का प्राय उसने था ना, ऐसा मिलेंगे रुपए उसने.
You have done it or not? Have you interacted with the petitioner?
Lordship, that is the compliance report that we are expecting from the department. We have not received it yet.
Okay.
Lordship, some time may be.
Heard Mr. B.C. Learned counsel for the petitioner. MS.
P. Agarwal on behalf of Mr. H. Gupta.
P. Agarwal, learned counsel appearing Mr. H. Gupta, learned CGC. Press for and is granted for the 2 weeks time to place the report. As directed by this court on 01/04/2026. List after 2 weeks. List the matter after 2 weeks. 2 weeks.
May I please, your lordship?
Yes, affidavit has been filed.
They have filed, my lord. They have
Yes.
filed, my lord. The case is, my lord, regarding provincialization of these petitioners under the 2017 Act, my lord. My lord, what has happened? We, with the, my lord, similar prayer approached before this honorable court, my lord, and this honorable court was pleased to dispose of the said writ petition, my lord, by way of an direction. My lord can straight away can come. Page 107 of my writ petition, my lord. Page 107, my lord. Lord, I am referring to paragraph, my lord, 7. In the event, all the petitioner herein and or any of them prefer such representation before the Director of Secondary Education Assam within a period of 1 month from the date of this order, the Director of Secondary Education Assam shall consider the said representation, and in the event it is found that the petitioners fulfill the requisite norms for having their services provincialized, shall have the cases of the petitioners verified / scrutinized by the jurisdictional district level scrutiny committee. Basing on the recommendation of the jurisdictional DLSC, the Director of Secondary Education Assam shall place the cases of the recommended petitioner before the state level scrutiny committee. Thereafter, the Director of Secondary Education Assam shall take appropriate steps for provincialization of the services of the petitioners whose cases come to be recommended by the state level scrutiny committee. So, my lord, initially the director had been directed that basing on our representation is required to examine our cases individually. Then, my lord, if we found that the petitioners come within the purview of the 2017 Act, then only, my lord, our cases is required to be examined by the district level scrutiny committee. Now, straight away, I beg to draw my lordship's attention to the impugned speaking order, which is at page 122, my lord. May I read, my lord? In the scene and period.
Earlier you have approached?
Yes, my lord. Earlier approach that direction. has been issued-
Direction to consider your representation.
My lord. Now,
Then
basing-
they have considered
They have
and
considered
rejected
and-
your claim.
Yes, my lord. They have considered and come out with this speaking order whereby our cases had been rejected for the reasons showed in the remarks column, my lord. That is now under challenge before my lordships, my lord.
Not eligible under section
My
2
lord.
as a provision due to non-comprehensive. Yes.
Because, my lord, our cases has not been, my lord, even placed before the district level scrutiny committee. If we, my lord, read the operative part of this order, my lord, speaking order, if my lord may be pleased, seen and peruse the order dated passed by the Honorable Gauhati High Court in so and so, and wherein the Honorable Gauhati High Court.
Same 48%.
Same has been reiterated, my lord.
The same 48% here
No, my lord, we are now here only 17% is there, my lord.
out of 48.
Yes, my lord. And other has been, I don't know, my lord, whether they have preferred or not.
Others have become more wiser than you.
Maybe, my lord, maybe, my lord. I don't, because, my lord, we are now, my lord, struggling to survive, my lord, due to, my lord, no employment, my lord. So, my lord, this direction which has been issued has not been complied in the letter and spirit, my lord. The director has not, even, my lord, our concern is that the district level scrutiny committee recommendation has not been taken care of by the director also, and wherefrom this remarks has been, my lord, ascertained is also not clear from the affidavit which they have filed also, my lord. So therefore, my lord, this matter can be remanded back, my lord, if I can satisfy my lord to consider afresh in terms of the earlier direction, my lord.
No, they have considered.
No, my lord may kindly say, if I read, my lord, accordingly, the case of the total, my lord, I am reading second paragraph. The 48 members of petitioner of the instant case were verified under the criteria of the so and so of the Educational Act as amended 2018 and was placed before the state level scrutiny committee, my lord. My lord, straight away had been placed before the state level scrutiny committee. The act says, first of all, my lord, the district level scrutiny committee is required to be consider the individual cases, my lord. Then, my lord, the recommendation or the not recommendation is required to be placed before the director. Then director place it before the state level scrutiny committee, my lord. Now, here is a case, the director himself has placed it before the state level scrutiny committee, and state level scrutiny committee has rejected. Now, that aspect of the matter, my lord, is now completely silent in the affidavit which they have filed, my lord. So therefore, my lord, my respectful submission before my lord is that as there is already a direction, my lord, in the earlier round of litigation that has not been followed, my lord, in the letter and spirit and in the true spirit, my lord. So therefore, my lord, that direction, if it follows,
Yes.
my lord.
Sarma ji.
Yes, ma'am.
Sarma ye mat.
Yes, my lord. Here in our affidavit also it is stated, my lord, that page 132, my lord. Second paragraph, my lord. Further, while disposing the petition by so and so, the Honorable Court by judgment and order that it directed the Director of Secondary Education Assam to consider the grievances of the petitioners and pass revision order in accordance with the provision of Assam Provincial Act 2017 as amended in 2018. In compliance with the said direction, the Office of the Director of Secondary Education Assam examined and verified the cases of the petitioner in terms of eligibility criteria prescribed under the Act of 2017 as amended 2008. So after examining and verified the cases
No,
of
that
the
I have
petitioner
seen, that I have
under-
seen. But
Yes.
what he is saying, Learned Senior Counsel is saying that as per the earlier order, you are supposed to place first before the
District committee.
district committee. Right?
Yes, my lord.
You have yesterday were placed before the state committee.
But my lord, it was examined and verified the cases of petitioner in terms of under the Act of 2017, my lord. And under the 2017 Act, it is stated that after DLC, LC,
DLC position is for DSC,
director. Then it is has to place, my lord, to state level scrutiny committee, my lord.
Where's the earlier order?
The earlier order, my lord, may be pleased to find.
107.
Yes, my lord, page 107, my lord. Whom to proceed with, proceed. 11, it is 3%. Or provincial additional teaching of platform vocational. No, I do this.
Page, para 7. You read 107.
107. In the event all the petitioners herein and or any of them prefer such representations before the Director of Secondary Education Assam within a period of 1 month from the date of this order, the Director of Secondary Education Assam shall consider said representations, and in the event it is found that petitioner fulfill the requisite norms for having the service provincialized, shall have the cases of the petitioner verified scrutinized by the jurisdictional district scrutiny committee. My lord, here it is stated that Director of Secondary Education Assam shall consider the representation, and in the event it is found by him that the petitioner fulfill the requisite norms for having their services provincialized, shall have the cases of the petitioner verified and scrutinized by the jurisdictional district scrutiny committee. Basing on the recommendation of the jurisdictional DLSC, the Director of Secondary Education Assam shall place the cases of the recommended petitioners before the state level scrutiny committee. Thereafter, the Director of Secondary School Education Assam shall take appropriate steps for provincialization of the services of the petitioner whose cases come to be recommended by SLSC. Here, my lord, Director has examined the matter and after examination.
Placed before the
it is found that-
district level scrutiny committee. Then on recommendation of district level committee, directors would place before the state level committee. Then only thereafter you have to pass this order.
My lord, but after considering all the matters by the director and.
No, you see,
found that they are not
as it
eligible.
was placed before the state level scrutiny committee in its meeting held so and so. This is on 122, page 120, impute order. But then it would be a mere formality.
No, my lord, the what?
Even if it is placed by
My lord,
district
my lord.
level scrutiny committee, same fate will be there.
No, my lord, formality is there, my lord, but it is the prescription of the statute, my lord, under the 2017, because the district scrutiny committee had the expertise. Now, whether our cases, my lord, had been considered by the district scrutiny committee till date or not, we are not aware, my lord, because this remarks column from only we could come to know, my lord. Had the cases been placed, they had the expertise, my lord. That's for the reason the committee had been constituted, my lord. That's the reason, my lord.
Here, my lord, in the order, it is clearly stated, Director of Secondary Education shall consider the said representations, and if found that the petitioners fulfill the requisite norms for provincialization, then the cases of the petitioners shall be verified scrutinized by the jurisdictional district level scrutiny committee.
That is correct, my
Come
lord.
to page 122.
Yes, my lord. It is in the
Remarks.
in first paragraph.
Not eligible under so and so due to non-recommendation by the concerned DSC. What is DSC?
District Scrutiny Committee, my lord.
Yes. Page 122.
District scrutiny.
Not all, but some of them. Maximum of them said that they have not been recommended by district scrutiny committee.
Yes.
So when you have not placed it,
When placed.
what is the question of recommendation by
Nothing is there.
district scrutiny committee?
Apuni to jane minors to come to meeting to come. Nothing is there.
Then, my lord, I have to take instruction regarding that, my lord, placing of the matter in a district scrutiny committee.
बहुत बेटा. Select-
Next week. Next week.
No, my lord, it will take time, yes, because there are several districts involved here.
No, you just ask them whether it was.
My lord, that's why, my lord, that's why, my lord, my submission is that can be remanded back, director will follow the earlier order, and I am not asking that we should be provincialized. It is the earlier order I am reiterating, that's all. Our order to follow.
So, my lord, regarding that, I have to take instruction, my lord. Here. Regarding the placing of the.
No, no,
district
see,
scrutiny
you're,
committee.
not all the petitioners, I mean, some of them,
Yes,
maximum of them said it has not been recommended. Had it been some other ground, we may understand.
Because, my lord,
And you have not rejected on your own, I mean,
Yes.
director.
my lord.
You have just placed before the committee. Maybe it's a procedure, but court has directed whether they are eligible for the provincialization. You could have decided there also.
My lord, it was the direction for the director to apply his or her own mind, my lord. That has not been done.
In the remand form itself, it is stated, not eligible under section 2H
Two minors.
of the Act 2017 due to non-recommendation.
By the concerned DSC. Friday, we'll take it up.
Yes.
We'll, at best, we'll remand it back.
No, ma-
Press consideration.
I will take the instruction, my lord,
Okay.
after 2 weeks.
And Mr. A.R. Goel, learned senior counsel, assisted by Mr.
NZ children.
learned counsel, MZ Chaudhary, learned counsel for the petitioners. Next para. It is noticed that the rejection of the request of the petitioners for provincialization appears to be not in accordance with the order of this court, earlier order of this court. Passed in WPC?
My lord, in WPC number
Just give the WPC.
5959 of 2019,
5959 of 2019,
my lord, an order dated
wherein it was, wherein the director, school education,
director of your secondary.
secondary education was directed to consider and place the matter before the district level scrutiny
Respective
committee.
district scrutiny committee.
Respective district level scrutiny committee for consideration of the considered petition for provincialization in terms of the Assam, what do you call it?
My lord, the Assam education provincialization of services
of teachers and reorganization of educational institutions,
You
bracket
repeat it.
close Act two thousand
Page one
17.
twenty-two, huh?
Page 111.
Assam Education Promotion and Reorganization 2007, as amended in 2018, huh?
Month.
List of the, Mr. Yushan, Standing Council,
Yes, madam.
Elementary Education,
Secondary Education Department.
on such, no, in view of above, the Mr. Yushan, Land Council, Learners, Standing Council, Elementary Education.
Secondary Education.
Secondary Education is, praised for and is granted 2 weeks time to obtain instruction. List accordingly.
Obliged, my lord.
24.
The counter affidavit has been filed and it has been brought on record on 27th July.
So, you want to file rejoinder? No.
But matter can be posted for hearing.
What is the matter about?
Service matter, my lord.
What service matter?
I was in the CRPF. I was
Okay, heard Mr.
PK Bora.
PK Bora, Land Council for the petitioner. And also heard Mr. MS.
Ardeep, on behalf of SS Roy.
Heard the Land Council appearing on behalf of Mr. SS Roy, Land CGC for the respondents. Admit list for hearing after 3 weeks.
25.
May I plead your lordship?
Yes.
Matter pertains to the death benefits from.
Affidavit has been filed.
No, Lordship, Lordship may have the order of 27 February, 27 February 26.
Huh.
Inquiry was.
Before that, Lordship, may I submit? Here, Lordship, what happened? The executive engineer wrote a letter to the chief engineer, Lordship, saying thereby that, Lordship, the service book of the petitioner has been lost during the shifting of the Lordship office from Udalguri to Tongla, Lordship. Thereafter, the chief engineer has wrote a letter to the executive engineer to reconstruct the service book of the petitioner, Lordship.
You have made an inquiry.
No, Lordship, not inquiry, Lordship. This is the internal communication between the department, Lordship. The chief engineer asked the executive engineer to reconstruct the service book and submit the pencil proposal of the petitioner, Lordship. This is the. Now the executive engineer, my friend, is Lordship representing. Lordship, we have to receive.
Huh.
Do the need.
Get instructions.
Huh?
Get instructions on that. Petition has come.
Lordship,
You have not received or what? It was 5 to
yes,
2026, long time back.
Get updated.
Heard MS?
P. Talukdar.
P.
Talukdar.
P. Talukdar, Land Council for the petitioner. Mr. N. Upadhyay, Land Standing Council, Irrigation Department, by placing the communication dated 05/02/2026 submits that the chief engineer irrigation department has directed the executive engineer Paneri Kalai Gaon Division, Irrigation, Tangla to reconstruct the service book of the
petitioner's husband, no?
Of the late husband of the petitioner, and to submit the same for family pension proposal. Mr. AIT Land Council, Standing Council, BTC, and appearing on behalf of the executive engineer, Paneri Kalaigaon Division, Irrigation, Tangla. Submits that he may be granted some time to obtain the instruction in view of the above communication stuff accordingly. And let this matter be listed after 2 weeks. In the meantime, so as to enable the enable Mr. Atria to obtain instruction as prayed for.
Obliged.
MS S. Sharma, Learned Council, appearing on behalf of Mr. B. Sharma, Learned Council for Account General, is present.
27.
May I please do that? My lord, present writ petition has been filed by 4 petitioner, my lord. They are the nurse, my lord, staff nurse serving in the Gauhati Medical College and Hospital.
What
at
is your
Gauhati.
comments?
My lord, initially they were appointed with my lord pay scale at rupees 6.
Pleadings are complete.
My lord,
Pleadings are complete.
complete, my lord.
Will list for hearing.
My lord,
An additional affidavit, lordship.
Huh?
They have filed an additional affidavit, lordship. I have to obtain instructions.
Additional affidavit or reply?
Reply has been filed.
my lord, reply has been filed. I have filed counter. And additionally, I have filed another additional
Okay.
affidavit.
What, Mr.
My
Mr.
Instructions.
My submission,
Mr.
my lord, it may be fixed for admission hearing, my lord.
Okay, Mr.
A Manna,
A.
A Manna.
Manab, Learned Counsel for the petitioners. Next,
Short date may be given, my.
Miss MS
D. Bora,
Deborah, Learned Standing Counsel,
Health and Family
Health
Welfare
and
Department.
Family Department. Praise for and is granted 2 weeks time to obtain instruction as regards the,
The ILO.
no, as regards the additional affidavit filed by the petitioners.
In fact, my lord,
Just after 2
it
weeks.
is a very similar order, my lord. I am seeking for a similar order, my lord. I annex.
No, no, we'll see.
I have to obtain
Yeah,
instructions.
It may fix, my lord, on
you
after.
take note of that also.
Yes.
2 weeks, we'll see.
Plus,
Lord, a date may be fixed, my lord. Very simple matter, my lord. A similar order, my lord.
2 weeks, after 2 weeks, give them.
Obliged, my lord. Obliged.
Item 29.
May it please, my lord.
Hmm.
This petition, my lord, we are challenging the post of respondent 8 and 9, my lord.
Hmm.
My lord, for the post of my lord Anganwadi worker and Anganwadi helper, my lord. That is the case, my lord.
Hmm.
My lord, pleadings are otherwise completed, my lord, from my end.
So,
They fixed for admission hearing.
it's already fixed for admission only,
My lord,
not today. On the prayer of Mr.
PR Sharma.
P.R. Sharma, Learned Counsel for the prayer, list this matter after 3 weeks. Mr. A. Attorney, who else, sir? BTC, you are for BTC.
Yes, lord.
Standing called BTC. Mr. I am at for respondent 8 and 9. Mr. H. Okrodi. State Council for State and Mr. D.K. Roy for
Respondent number 10.
respondent but are present.
My lord, it may kindly be reflected as fixed for admission hearing on.
It's already registered for admission.
If it is fixed.
For
my lord,
admission,
then
you just.
Okay. Obliged.
31.
Earlier, he was removed from service. This court interfered with. And this court interfered with, and it was set aside by this court. Your lordship will kindly see page 43. It has to be a hard final even. I am.
So we'll hear it today or when?
I am ready. It's a.
Or else we'll admit and list for hearing on fixed date. So that it can be taken up.
So that it can be taken up.
Yes.
That is the problem.
But what we have seen is with the admission matters are long.
On the
So
face
it's
of
difficult
the,
to take it up.
on the face of the record, my lord,
So we'll fix it for, we'll admit and fix for hearing on a particular date.
Otherwise,
Is maybe, I mean, agreed by.
Next week, my lord.
Not next week, after 2 weeks.
No problem.
Let have this.
Lordship will record that they are not intending to file any reply, Lordship, and Lordship will take up for hearing, Lordship.
Okay. We'll admit and list for hearing
Yes, sir.
on a particular,
Yes.
after 2
It's a
weeks.
question of law only, nothing else.
And Mr. B.D. Das, Learned Senior Counsel, assisted by Mr.
HR does.
H.R. Das, Learned Counsel for the petition, and also heard Mr. P. Nayak. Nearly 2 months. I tend to forget you.
Lordship.
Maybe you have stopped becoming more prominent.
Probably, Lordship.
For this, your additional advocacy or for
Yes, Lordship, additional AG for PWD.
additional advocacy for state respondents. Admit list for hearing on,
Next week, any day.
not next week, after 2 weeks. Give the fix
Yes. For hearing.
for hearing. The record will be required, no?
No, it's not like this. Question of law, my lord, nothing else. For hearing.
May I please not, sir? You have to receive any instruction, Lordship, for a 3 weeks time will require, Lordship.
And Mr.
A.Y. Chaudhary.
A.Y. Chaudhary, Learned Counsel for the petition, as spread for by Mr.
3 weeks.
Mr.
A Chakraborty.
S.
A.
A. Chakraborty Learned Statement. For that 3 weeks time is granted to obtain instruction.
Obliged. May I please, Lord. My Lord, in this matter, my Lord, I was transferred, my Lord, from one state to another. And my transfer was stayed by the Honorable Court. But my Lord, now, my Lord, the respondent side is cooperative societies, my Lord. Now they have affected my transfer, my Lord. There is a stay order from the Honorable Court. I may be allowed to bring this order on record by way of filing an additional affidavit.
What do you have challenge here?
Transfer order, my Lord.
By whom?
By cooperative societies.
Now?
Now, my lord, it was under stay, my lord, and the cooperative societies affected my transfer. I have to join, my lord. My transfer order has been affected, my lord.
So go.
But my lord, my ground for my transfer is stay of the transfer is, my lord.
There is a stay.
Stay, my lord.
Then?
Then, my lord, I want to bring it on record, this, my lord, by filing an additional affidavit.
No, I
In
don't.
spite of there being an stay order, my lord.
I've not understood what you want to say. See, you have challenged a transfer order.
I have challenged a transfer order. Honorable Court, my lord, interfered and stayed the transfer order.
15/3/2026.
My lordship.
Then
And in presence of that stay order, my lord, the department has caused, my lord, they have transferred me, my lord. That is what I want to say, my lord.
no, despite the stay or the interim
Despite the stay
order,
order, my lord,
your transfer has been affected.
affected, my lord.
Then what is the remedy?
That, my lord, I
You
want to
file a
bring it on
contempt. You file a contempt.
my lordship. That I'll take instruction from my client, my lord, whether because once I initiate a contempt petition, my lord, my client, my lord, because this is engaged matter, my lord, the council is saying that.
Then nothing remains. If
My
you
lord.
don't want to pursue the remedy.
That, my lord, that is why I will bring it on record.
Okay,
this
heard,
order.
Mr.
M.K. Das, my lord.
M.K. Das, Learned Counsel for the petitioner. Not heard. Mr. M.K. Das, Learned Counsel for the petitioner submits that although interim order has been passed, staying the transfer of the petitioner, same has been given effect to by the respondent authority. Therefore, pressed for some time to take appropriate steps.
My lord.
To take,
I'll file it.
press for some time to obtain instruction.
My lord.
And take appropriate steps.
Deeply.
Whereas law list after 3 weeks.
Appearing for Election Commission of India, Your Lordship.
Why?
Lordship, these
Cooperative society, order passed by the Cooperative Society and Election Commission of India, what are you going to do? What is your role?
These were code of conduct transfers, Your Lordship, during the election process. Now the code of conduct has been withdrawn.
Okay.
So
So you are no longer
we have no role to
Necessary
play,
party.
Your Lordship.
okay, we'll see.
Lordship.
You will be there. MS so and so.
S Katakiyal.
S. Kathak, Council for Election Commission of India, Respondent Election Committee of India is present.
Obliged.
Deeply obliged. May I pray for a date? Deeply obliged. No. 3 weeks. 3 weeks.
In effect, you don't want to pursue the
My lord.
petition.
My lord. Obliged.
We are not extra copy yet to serve, Lordship. That's why I am unable to bring any.
I think long time back, I have told you, this court has told you not to make submission that, not to make such submission. You furnish. And MS?
D. Basumatari.
Learned counsel for the learned counsel for the petition. Expressed for by Mr. A. Chakraborty suggesting for the 3 weeks time to file response. On understanding, we're not recording.
35. Lordship, we have not received the instructions on this one, Lordship. One more
Mr.
opportunity, Lordship.
S.B. Laskar, heard Mr. S.B. Laskar learned counsel for the petitioner. Expressed for by Mr.
A. Goswami, Lordship.
A. Goswami learned counsel for
Forest Department.
Forest Department. Further 3 weeks time is granted to obtain instruction and file affidavit of opposition. MS? B. Sharma learned counsel for respondent number 5 is present.
Highly obliged.
We'll resume at 2.
For order.
May I please, your Lordship? Lordship, 2 weeks time may be granted, Lordship, to
For what?
to take steps pursuant to order dated 24/7/25.
Hmm?
We have filed IA, Lordship, to implement the respondent number 9.
Hmm.
That IA was allowed, Lordship, and we were directed to
On the prayer of Miss MS?
F Intest.
F. Imtiaz. Imtiaz.
Lordship.
Learned counsel for the petition. Further 2 weeks time, 2 weeks time is granted to take steps for a notice upon respondent number. Newly implemented respondent number.
Lordship. Sorry, Lordship. We have taken step, Lordship, on 24/6.
That means that steps has been
But
taken.
office note says that we have not taken step, Lordship. Let the office be verified.
Submits that so and so. Steps has been taken. So no for notice upon respondent, newly implemented respondent
9. Lordship.
9. Next paragraph. In view above, let this matter be listed after 4 weeks. MS and as you can learn the counsel appearing on behalf of Mr. P. Naik, additional advocate for public works PWD is present.
Item 38, 39, and 40.
This is the common order 11/8/22 and 23 But till that
Complied.
not complied, has not complied.
Your Lordship, that the common judgment was passed on the based on a division bench judgment. Your Lordship, in that judgment, also there was a confusion regarding recordable date from which date qualifying service is to be considered, counted. Your Lordship, now on last 20th, Your Lordship, the Honorable Division Bench has clarified it that it is from the date of regularization. Now, it is proceeding now.
Finality, my lord.
In their favor. In their favor. No,
Earlier, there was a dispute whether it
no,
is.
no. Therefore, that has been settled now by division bench.
Yes, there was confusion that their claim was from, it is to be counted from the date of initial appointment. Now, Honorable Division Bench says that, no, it is from date of regularization.
Now,
Only just 2 weeks before it.
no, it's in their favor or against them?
State appeal was dismissed, but there was confusion. Now it is clarified.
Now you will comply.
Not complied, my lord, till that, my lord.
Till that not complied, Your Lordship, just on 20th, that clarification given by this Honorable Court. Your Lordship.
That's why I'm asking, you will comply now.
Definitely we will comply.
Heard Mr. K.R. Padgiri, learned counsel for the petitioners. A spread by Mr.
K. Kumar, Your Lordship.
K. Kaur, learned additional advocate.
Your Lordship, as a counsel, because it is a contempt matter.
Learned counsel for the
Foreign practice.
alleged contemners. Let this matter be listed after 3 weeks. You comply?
4 weeks, Your Lordship.
4 weeks.
That may be fixed, my lord, contempt
4
matter, my
weeks.
lord, of pen petitioner, my
4
lord.
weeks. They are
action matter, my lord.
going to comply because of that confusion only. 4 weeks. Next.
Obliged.
Your Lordship.
Yes.
My lord, this matter is returned from the mediation, my lord. And in the mediation, it has not been settled, my lord. This is the recovery has been done from the retirement benefit, my lord, without issuing the notice. So matter may be fixed
Lord
for
Mr. B. Kumar, learned counsel for
admission
the
hearing.
and Mr. A.K. Datta, learned counsel for learned CGC.
Yes,
Respond to one.
all the respondents.
Good respondents. It was referred to mediation. However, same could not be settled. As reflected by the report of the mediator, according list this matter for admission after 3 weeks.
My lord. 42. Item number 42, contempt case, my lord, this order has been complied, so it may be closed.
Mr. B. Kumar, learned counsel for the petitioner submits that order of this court dated so and so has still been complied with. Accordingly, step contemporary stands closed. 43 also.
43, my lord, against the order dated 25/2025, it has not been complied till date, my lord. Neither reply has been filed from the.
Yes, then.
Lordship, I am appealing for the contempt number 2, Lordship. Lordship, we require some time, Lordship, to file our affidavit.
Heard Mr. B. Kumar, learned counsel for the petitioner on the prayer, Miss MS.
Ardev, on behalf of.
Ardev, learned counsel appearing on behalf of Mr. R.K. Dev Chaudhary.
SS Roy. on behalf-
Sorry, S.S. Roy, learned counsel for Ellis Counter. That this method will listed after 3 weeks. So as to enable the Ellis contemnant to file affidavit.
My lord. Deep lord.
Right, Lordship.
Item 44.
Wait, please, Lordship.
Yeah.
Lordship,
Yes.
As per last order, we have taken step.
Huh?
As per last order, we have taken step. The matter is related to the family pension.
Respond number 7.
Yes, Lordship.
Mr.
Ahmed Shakir.
Ahmed Shakir, learned counsel for the petitioner, is present. Office note dated 31/7/2026 reflects that although neither the ID card nor answer notice has been received, the item is shown delivered to addressee. Accordingly, the service of notice upon respondent 7 is deemed to have been served, deemed to have been effected, list board admission after 3 weeks.
Explain for respondent number 2.
MSB S. Bora, learned state council correspondent 2 is present. Yes,
Lordship, fix in next week.
3 weeks.
3 weeks.
for admission.
May I please, your lordship?
Yes.
Lordship, may kindly come to order dated 5/6/26, lordship. Prior to that, lordship may come to order dated 5/6/26.
5/6.
26. Order dated 5/6/26. My proposal for promotion, lordship, already placed before the promotional committee, lordship. And it was also considered. But till now, the promotion has not been given, lordship. And this man is retiring in December, lordship.
Yes, which for
Lordship, he is not appearing. On last date also, someone came and said that we need time for 1 week time. They just want to deprive him, lordship, because he is retiring in
around.
December. Lordship can direct it, lordship, because
he is around.
I don't know, lordship, whether he is around.
You ask, find out, Mr. Chamo.
Okay.
Say after some.
46.
May President, this case, I am appearing for respondent 1, 2, and 3. 2 weeks time may be given for filing reply.
You are for?
I am
State.
for respondent 1, 2, and 3.
Which restaurant 1 and 2? 1, 2 and
1,
3.
2, and 3. Came with that. 1, 2, and 3.
1, 2.
1, 2, and 3.
State respondents.
State respondent. I'm told.
Heard Mr.
BP Sharma.
BP.
P. Sharma.
P. Sharma.
What? BP Sharma.
BP Sharma. Learned counsel for the prison. And the prayer is prayed for by Mr.
K. Gupta.
K. Gupta, learned counsel for the respondent. State counsel.
Amtron, on behalf of Amtron.
Huh?
Amtron.
Learned
Government
counsel
executive.
for respondent 1, 2, 3. But the 2 weeks time is granted to file. 2 weeks.
2 weeks.
File affidavit in opposition.
Lordship, interim is there, lordship.
Interim order passed and let's continue.
So date may be fixed.
2 weeks, let him file first.
Lordship,
Give them.
give them.
47. 47.
Any idea, Mr. Naik?
Lordship.
Last time this on 4th Jigs, they said Silma matter is pending before the affects court.
Yes, apex court decided in favor of the appellant's court.
So
Same matter was relied upon by some other petitioners before the division bench. In that matter also, division bench took a view in favor of the petition. So otherwise it's okay, lordship, but here the ground for review is different. Here they are relying upon 2 notifications, lordship, one of 1986 and one of 2003. So they are saying that at the time of adjudication of the matter, these 2 notifications could not be placed. That is the ground here, Lord. That is one development, lordship, but there is another development also, lordship. The judgment that was passed by the Supreme Court, lordship, and the judgment that was relied upon by the division bench, lordship, has in the meantime, lordship, another bench of the Supreme Court has said this is not a binding precedent.
So it has been referred to larger bench.
Not yet referred, lordship, but another bench declined to follow that particular judgment, lordship. And they say that Umadevi and official liquidator is binding for us. This judgment, Jaggu plus this Sukhendu Shekhar is not binding for us.
Jaggu is not binding.
These 2 specifically mentioned.
So we have relied so many matter and this we have relied Jaggu and
Exactly
this
what,
was so
lordship,
many matter.
So that has now been cleared, lordship. I mean,
Okay, none appears for the petitioner on call.
No.
What review they want?
They want review of the judgment wherein, lordship, the claim of the petitioner for regularization was dismissed.
Rejected. Dismissed.
Dismissed.
Okay. None appears for the petitioner on call. However, Mr. Pinayak learned additional advocacy for the respondent is present. This after 4 weeks, we'll see.
I'm appearing on behalf of Mr.
Record are present. Yes, sir. R.K. Talukdar. Or who are you? What's your name, please? Sorry. Huh?
Adas.
Adas.
I am appearing on behalf of Mr.
Obliged, sir.
49.
In this matter, my lord, we are filing our affidavit by tomorrow.
What is the matter about?
Lordship, the matter is about removal from service of
Okay.
a CISF constable.
Hmm.
But Lordship, we had filed the petition on 17th of March and 17th of March. And now we are in August. We are yet to receive the affidavit in opposition. 17th March. By tomorrow, Lordship, 5 months gone. And both myself and my wife, who was also a constable, both have been removed on very malified manner.
Okay, heard Mr.
D.S. Bhattacharya.
This is a Bhattacharya learned counsel for the petitioner. And next prayer is prayed for by Mr.
M.R. Adhikari.
M.R. Adhikari learned counsel for.
Respondent number 1 to 6.
You are CJC.
CJC.
CJC learned counsel, learned CJC. Submits that. No, Mr. M.R. Adhikari learned CJC submits that he will be filing the affidavit in opposition by tomorrow. Accordingly, fresh for listing after 2 weeks. Prayer list after 2 weeks.
A particular date, any date.
Then after 2 weeks, huh? Give the date.
Any date. 9th. Much obliged, Lord.
May it please your lordship.
Yes.
My lord, this matter pertains to my lord for regularization and pension, my lord. And the respondent is my lord PHE. The my lord, petitioner was appointed, my lord, at page 19.
Why is it listed for orders today?
I have already taken a step, my lord.
Hmm?
I have already taken a step. my lord.
Mr. So-and-so learned counsel for the petitioner is present. Anybody appearing for respondent number 10?
I am for the PHE department, lordship. 10 is finance, my lord.
Office note 1307-2026 reflects that neither the editor nor any answered notice has been received back. Respondent number 10. That's the postal report indicates, postal trade report indicates that the consignment appears to have been delivered. And we have let this matter be listed after 2 weeks. Mr.
Ego Sami.
Ego Sami. Oh, who, 1, 2, 3, who else are there? From 1 to, starting from
1
1.
and 2, lordship.
Huh?
1 and 2. Respondent 1.
1 and 2.
Lordship, I am for respondent number.
B dekha.
R Deka, your lordship.
R Deka.
Number 4, 5,
And who else?
6 and 7.
9. B Chakrabarti. A Borthakur
I am 11.
are present. We'll see after 2 weeks.
All right.
Yes.
1945.
I apologize for that on lakes in a different court, my lord. The difficulty is, my lord, it's all set to take a decision, but the ASSC, the whole
Yeah, I've seen that.
corporation
You're
is in
supposed to
defunct.
reconstitute.
It has not been reconstituted.
Okay, we'll grant you 3 weeks time for that. Mr. Heard Mr.
M. Ahmed Lutfi.
M. Ahmed Land Council for that. Mr. H. M. Land Council, but the respondent
Respondent for A is similar.
Respondent number
2 to 4, my lord.
2 to 4.
I'm for one.
Submits that the committee is yet to be constituted by the government. Therefore, prays for listing of the matter after 3 weeks. Next period. Praise the Lord,
this
after 3 weeks. Miss
Because this man will retire in December, Lordship.
MD
Matter will become infectious, Lordship.
State Council,
Standing Council Transport Department.
State Transport is present. This
The date may be fixed, Lordship, after 3 weeks later.
3 weeks, give the date. He is retiring December.
I understand, my lord. My
Let
hands are
it be
also
ready
tied.
to other, whether you want to give, then you give, or you reject it.
The last order, like the 2986, but the matter has come today.
Okay, why did, there's an order, the matter was supposed to be listed on 29/8/2026.
Lordship, that is an inadvertent mistake by the court, Lordship, because it was to be listed after a week, Lordship.
Prayer is allowed.
The date, they wrote the date wrongly, 29/8, Lordship.
Okay. Anyway,
Or Lordship can fix it on 29/8 now, Lordship.
29/8. 29.
29 and like 12
Also right.
Almost.
You prayed for your, on your behalf, it was prayed for 1 week. It's wrongly listed 29.
My lord.
So now we are listing it 29.
29.
So positively, Lordship, they will decide on that.
That
Because-
part.
Because already September is coming, Lordship. He will retire in December.
Everything will be positive. Don't think about negativity.
Lordship. Here in the case, Lordship, the notice issued, Lordship, but the extra copy not received. from
Not
part of
appears for the
petition.
petitioner on call, office note dated 30/07/2026. Shows that reflects that although neither adequate note answer notice has been received in respect to respondent number 4 from the postal concernment, the postal concernment shows that the concernment has been, as appears to have been delivered, considering I will let this matter be listed after 3 weeks.
Must have this.
Item 53.
May I please, your lordship? Lordship, I am for the petitioner. Lordship, my humble submission before your lordship is that kindly allow me to implead one party, that is Fazal Ahmed.
All those things are not required. Similar matters were taken up today by court number 4.
Lordship,
matters were
please,
fixed
submission.
at-
For the
On
justice.
10 and 8.
Huh?
On 10/8/2026, those matters were fixed, so let it come there. That prayer was not allowed there, even notice were also
Thank you, my
not
humble
issued.
submission for
Yes,
the
it
acts
is
of
Ask
justice.
Mr. So-and-so learned counsel. for
The private
because for
respondent
the
is also here. Lord.
Proper adjudication of the
Who-
this
come for admission.
behind
Submit
additional
that he
affidavit
may
kindly
be
be allowed.
allowed to implement
Implead Fazal Ali Ahmed,
No,
one employee of the
some
same
persons
department,
in
and-
a writ petition, please, however, Mr.
and additional
Yeah,
affidavit may
permanent
kindly be allowed.
State Council, huh?
Or the Health and Family Welfare Department. Respondent number
State
1 to 8.
Standing Council, Health and Family Welfare Department, and Mr. You, Bharadwaj Land Council Correspondent submits that similar matter has been fixed.
On 10/8/2026.
Similar matter is fixed on 10/08/2026. Therefore, same may be
Clubs together.
list along with those similar papers. So considering above, let this matter be listed along with WPC.
WPC number, Lordship.
Wait, let me.
on
But at this juncture, I may kindly be allowed to implead that party for the.
Four-
proper-
4028 of
4028/26, 4028, WPC number 4028/26, then WPC number
One will-
4044/26, then WPC number 4045/26,
Similar matters are listed there.
and WPC number 4072/26.
Yes.
Applies.
Lordship, I have one.
We are
more
not
sub-
permitting, once other court has not permitted,
Yes.
you may
Sir,
file, we'll
that was
consider.
not my submission in those.
Before that, you may, in the meantime, you file it, we'll
You
consider.
don't need a permission.
Yes,
Highly obliged.
That
no
may kindly be recorded, Lordship.
no permission is required. No.
Obliged, Lordship.
Item 54 for hearing.
Any. Yes, which put the respondent?
Respondent bank is sent. May I present also?
You have been dismissed from service.
Yes, Lordship.
Where's the respondent?
In the morning, he was there. We had a case together, but now he's not coming.
Huh?
Now I don't know, sir, where he has gone.
So what is to be done?
A fix that may be fixed, Lordship.
See, your ground of challenge is that the regulation 40 of what is called?
Lordship, in brief case is that
You have been dismissed
I have been dismissed from service
on account of your conviction
on account of my conviction.
with a
But
in
in
criminal
that case
case.
also certain procedure is to be followed as per staff service regulation of the.
Let us see.
Let us see.
Employee Service Regulation 2013. Where is
First Lordship, let us come to impugn order 39, page number 39.
39. Can you find it out?
Lordship.
Pursuant judgment in the Court of Chief Judicial Magistrate so and so related to Longley Road branch, the following punishment awarded to you in terms of Regulation 30 sub Regulation 3 A and B of Assam Gramin Vikas and Section 10(1)B of Banking Regulation. Yes, dismissal.
So now it is in page number 90, regulation 30 is there, page number 90. Page number 90. Point number 3, regulation 3, sub 3.
90.
90.
An officer employees are
And
liable to dismiss of to any of the other. Yes.
So here an officer or employee shall be liable to dismissal or any other penalties. It may be dismissal, it may be any other penalties which has been referred to in regulation 39. Now let us come to regulation 39, Lordship. Regulation 39 is in page 94.
Regulation 39.
2 is employees. He is an employee. He was a sub-staff. So measure.
39.
Yes, Lordship 39 2. Page number 94.
94.
39 2B. Major penalties has been defined for the employees. One is fine, withholding of increments, withdrawal of special allowances, reduction of pay to next lower stage, removal from service, dismissal. That means as per regulation 30, any of the dismissal or any of the penalties can be imposed upon. Now, as per regulation 439, enquiry is a must, but there is a provision where enquiry can be waived. Regulation 39 can be waived. That has been detailed in regulation 40. Waiver of the procedure, page number 95. May I read, Lordship?
You have to read it. An officer or employee shall be, your employee
I am an employee.
shall be liable to dismiss or to any of the other penalties referred to required summary. It's addition to that. It can be dismissed in or other any other penalty and as per regulation 39 if he is committed to prison for that or is convicted of an offense which in the opinion of the organization or has bearing on any of the affairs of the bank. You are convicted on for what?
Convicted on a.
No, convicted for what?
This is a criminal proceedings that have been, there was a allegation that there is a misappropriation of the fixed deposit.
Of the affairs of the bank.
Yes.
It
But
is correct.
Now Lordship, I will.
What is this? This is 33. So then.
Lordship.
So we're not concerned about this 39.
Yes, Lordship.
Major penalties were not concerned.
Yes, Lordship.
It's in dismissal is in it can be dismissal or any of the penalties.
Any of the penalties
under 39. Yes, come to page 40.
Yes,
Sorry,
95. 40.
Requirements may be waived by the competent authority. No.
Yes, Lordship. Now I will draw your attention to the E after E, provided that no requirements of regulation 39 may be waived unless the reasons for doing so are recorded in writing and placed before the board. And in the instant case,
you're simply saying that this has not been placed before the board.
No, that has not been recorded also.
Record is their conviction. Conviction in connection clearly shows.
Not, but
page. Where is the order? Where is the order? Impugn order?
Page number 39.
39. Yes, Karim Gauhati so and so related to Lengai load with the following punishments awarded to you in terms of regulation. Related to in the accordance with the Karim Gauhati so and so, GRK so and so. This is the reason you have been convicted.
Reason, but it has not been placed to the board. That is a must because
where we can say this is an order.
Yes, Lordship.
Where is the decision of the board?
No, that has not been India reply. When India reply, they have not come out that has been placed to the board. Let me come to the page, para 20, page 11, Lordship.
Page
11 of the writ petition, para 20. Lordship, my point, simple point is that dismissal can be done. Dismissal or any other penalty.
Who has filed this?
Page number 11, para 20. That it is stated that the disciplinary has committed serious error while passing the order of penalty fight.
Para 20, there is no para 20.
Page 11 of the writ petition, Lordship.
Huh?
Page 11 of the writ petition.
Writ petition?
Yes, Lordship.
So come to affidavit in opposition.
Affidavit in opposition, Lordship, that is replied in para 11, page 116.
Para 11.
Para 11, page 116.
Your reply?
No, their bank's reply.
To the statement?
To the statement of para 20 of my affidavit, of my writ petition. That in reply to paragraph 20 of the writ petition, the respondent denied that the disciplinary has committed serious error while passing the order of penalty on 78/2018. The petitioner has not given any reason as to why he has not challenged the alleged serious error of the year 2018 after much delay in the year 2025. Section 10(1)(b)(1), the Banking Regulation Act 1949 prohibits the banking company from employing or continuing the employment of any person who has been convicted by a criminal court or an offense involving moral turpitude. Further, the requirement of Regulation 40 is within the discretion of the competent authority of the bank as to whether the waiver of the procedure under Regulation 39 is required to be waived or not. So they have not come out with the statement that it has been placed before the board. That is the issue, Lordship. Now, it is stated that the petitioner was given sufficient opportunity to defend himself in terms of Regulation 39 2B412 as the show cause was issued on 27/10/2015 and the order of dismissal was issued on 17/8/2018 after the petitioner was convicted by the Court of Learned CGM Karimganj. So, Lordship, here my reply is I have replied this in my counter affidavit in page number 129, para 9.
Hundred
129, para 9. That as regard the statement made in paragraph 11 of the affidavit in opposition, the answering deponent denies and disputes the averment made by the respondent. It is further stated that there is no intentional delay and laches on the part of the petitioner in as much as the delay caused in filing the writ petition has been duly explained in the writ petition. That apart, the respondent authorities have admitted the letter dated 24/4/25, that is in page number 77, Lordship, that as the disposal of the appeal preferred by the petitioner, and if the same is presumed to be correct, the writ petition has been filed within the time. Lordship, now it is also denied that the petitioner was given sufficient opportunity to defend himself in terms of Regulation 39B2B512 filed show cause notice dated 27/1/2025. Lordship, this show cause notice dated 27/2015 is in page number it is in page number, Lordship, 23 and 24 of the writ petition. Annexure 3.
So rule 39 and 39 doesn't come into play. I mean regulation 39. You have been dismissed under rule 30, regulation 30.
Regulation 33,
Three.
Regulation 30 is conduct part. Penalty part is covered under 39 only, Lordship.
No. Because it doesn't provide for dismissal. Its highest is removal. Therefore,
Yes.
under rule 30, you can be dismissed from service on conviction.
No, dismissal.
If it's a bearing with the
Lordship. Just a minute, Lordship.
affairs of the bank. So only issue is whether this waiver proviso to regulation 40, what is this regulation 40? Page
Lordship,
79.
Lordship, maximum punishment is for employee also dismissal. 6.
Huh?
94, page number 94, 2B6.
B6.
2B6.
Oh, dismissal. Yes. Dismissal is also there.
Yes, Lordship.
So therefore, they have, unless the reason for doing so are recorded in writing and placed before it. Yes. Whether this reason has been recorded or it was placed before the board.
No, that, my lord, does not appear to have been done. The proviso, the requirement of the proviso, it appears that that has not been done. However, my lord, otherwise, if I may say so, my lord, he has filed a criminal petition which is pending in this honorable court. Now, my lord, if he is acquitted of the charge, he will be reinstated also, my lord, and he will get all the benefits that he is otherwise entitled. That is the, my lord, simple. So it would be perhaps, my lord, without going into the intricacies of the matter, if he can, my lord, pursue that matter in which he has obtained a stay, but the stay is only of the sentence. He has been convicted by two, my lord, concurrent criminal courts. And that is the only reason that he was dismissed.
Okay.
Now, there was no separate departmental.
So once your conviction, dismissal is on the basis of conviction.
Yes, and
If the conviction goes,
yes,
he'll get everything.
yes.
So at this stage,
Regulation 39,
when
Lordship has
the dismissal is not been stayed,
yes.
no,
Yes,
the
Lordship-
entitlement can be
Lordship may
given.
recall the
Conviction has not
testimony
been
of earlier.
Conviction has not been sent,
Conviction-
sentences has been suspended.
That's what I'm saying.
The Lordship may
Now,
recall.
until and unless your dismissal is based on the conviction,
Yes, Lordship.
Yes.
right?
But there is technical error while passing the order.
Huh?
There are procedure lapses that has not been followed in the instant case.
He is saying, my lord, that the proposal for dismissing him, my lord, the waiver of the procedure, that proposal was not placed in writing before the board. That admittedly appears to be the case, my lord, that is specific. Now, but if we take it otherwise, my lord, the prejudice angle also has to be seen. Whether, my lord, that would have made any difference in the matter. Because even if Lordship has gone through, I think, Regulation 30, Regulation 30 provides that if he is convicted by a criminal court, then he has to be, my lord, subject to the major penalties under 39. So 30, 39 and 40 are interrelated in that manner. 30 says that yes, you can.
Therefore, why don't you pursue that criminal
And
revision?
I will pursue that, sir, Lordship. But my point is that 30 is very specific.
See, for example, suppose if your conviction is set aside, matter ends there. If it is not, whether the procedure has been properly followed or not. So today, if we say it has not been properly followed, again we'll have to remand it back.
Yes.
Again, they will have to process. In the meantime, if you are again dismissed, is not it? And if the writ petition is not allowed, I mean the criminal petition is not allowed, again things will be different. So it's better you pursue that.
Yes, Lordship.
And we'll list thereafter.
Lordship.
Which is a matter of 2025.
Lordship, right at this
that
moment.
will be better.
Lordship,
Because otherwise this will be unnecessary. Suppose today if we find the procedure has not been followed, we'll remand it back again. Again, you'll be dismissed by following that.
It will relate back to that date of conviction.
Yes.
Lordship, I will take few minutes from you, Lordship.
No. This is my view. So
this is I agreed. This I agreed.
That matter.
Second point is
not today.
Second point. Second part is
maybe he has fairly admitted it appears to have no reasons and it was not placed before the board. But problem is the dismissal is based on the conviction. Now if we found, that's why assuming that you are correct, assuming your submission, I mean accepting your submission, at best we'll remand it back again. We just cannot, that you should be reinstated. We cannot be done like that.
But for the time being, I accept, Lordship. I have second part of this writ petition, Lordship. I have been dismissed in the year 2018. I have been struggling with 2 square meals. I am entitled from some benefits. Number one is gratuity. Lordship, now,
even after dismissal?
Yes, Lordship. Page 106 of the Staff Service Regulation. Page 106. At least that if I get the gratuity also, if I get the leave encasement also, if I get some compassionate allowance also, I shall be saved. I shall be able to save my family. Page number 106, Lordship. Regulation 72(2).
Provident fund you have already withdrawn.
Provident fund already withdrawn.
Withdrawn, right.
Every officer or employee shall be eligible for gratuity on so and so. Retirement, death, disablement, resignation, termination of service in any other way except by way of punishment
after completion of 10 years of service,
Hmm.
provided that in respect of an employee, there shall be no forfeiture of gratuity for dismissal on account of misconduct, except in cases where such misconduct causes financial loss to the bank, and in that case to the extent only. So here, no financial loss has been caused to the bank. There is no notice to the employee concerned, informing him that certain amount of financial has occurred to the bank. So he is entitled for gratuity, even if the dismissal order sustains at later today or later stage also, but he is entitled for gratuity. Lordship, I am struggling for 2 square meals. My daughter is a dropout because of I could not, Lordship, I could not accommodate her for higher studies for financial reasons. That is my first submission regarding the gratuity, Lordship. Next, leave salary. I am entitled to leave salary also, Lordship. Because in the
No, it cannot be piecemeal. We'll consider everything, you pursue that and we'll get it done.
but
Even if it is dismissed, if your conviction is sustained, we'll consider on its own merit, right? But tomorrow, if it is allowed, nothing doing.
No,
Again, you will have to go back to square again.
No, at least
So you try make an attempt to get it disposed of.
No. For example, I presume that the conviction has been appealed by the High Court also. Even then also I will be eligible. But after how long it will take time? But I am struggling with the.
That's why you make an attempt, you make a mention, get it done, get it.
That is being looked after by some other advocate, Lordship. I am not there.
No, problem is
My issue is he is entitled for gratuity, he is entitled for leave salary, he is entitled for compassionate allowances, everything is entitled. Sooner or later it is to be given, but at least the family will be saved. On humanitarian ground also it is to be looked into.
At this part, you obtain instruction. As per the regulation, if he is entitled, how can you tell it?
And then
all right,
leave salary also.
Hard mister, whatever.
Whatever retirement benefits, no, Lordship may kindly indicate in the order that will help.
Hard Mr.
R.K. Sharma.
R.K. Sharma, learned counsel for the petitioner. The petitioner challenges the order that is 1706/2018 passed by the chief manager within bracket personal bracket close and disciplinary authority, whereby he has been dismissed from service on conviction in a criminal case being year case number 479 of 2008. List of the conviction and sentence of the petitioner. As per rule, as per regulation, continue, as per regulation 30 within bracket 3 A and B of Assam Gramin Vikas Bank within brackets officers and employees bracket close service regulation 2013, page 39. Next paragraph. The conviction and sentence of the petitioner is pending final disposal before this court in criminal revision petition number
66 of 2021.
66 of 2021, in which this court has suspended the sentence. List of next paragraph. upon you write also heard Mr. Huh? On top. A. Ganguly, learned Standing Council. AGB, huh? Assam Gramin Bikas. Respondent Assam Gramin Bikas Bank. Then you write all this thing. Huh? Upon hearing the learned counsel for the parties, this court is of the considered view that. What is this?
This is a judgment of the Chhattisgarh High Court.
Why not now? Why not now? Why not disposing of the matter? I'm of the considered view that it would be appropriate to finally consider and dispose of this matter after disposal of the criminal petition. Please, how about considering the other what is page? What is this regulation? 72, 106. Considering the other grievance
72 2E.
as regards the claim of what do you call it? Retirement benefits? No, as regards the gratuity. Having noticed the regulation 72.
Yes, 72.
72, particularly the proviso, particularly the proviso to regulation 72, where it is provided that an employee, provided in respect of an employee, there shall be no forfeiture of gratuity for dismissal on account of misconduct, except in cases where such misconduct causes financial loss to the bank, and in that case to that extent only. Page 106, proviso that. Interest of justice should be served if the respondent so-and-so bank is directed to consider the same in terms of the said regulation. Consider the grievance of the petitioner in terms of the aforesaid regulation. Stuff. In view above, let this matter be listed after 3 weeks. 3 weeks.
If they did.
On the next date, Mr. A. Ganguly, Learned Counsel, to place the instruction, place the instruction that would be it's instruction as regards the decision that would be taken by the respondent bank as directed herein above. We direct them to consider as per this thing, and then they'll produce.
There are two parts also, leave salary also, and the pension, compassionate allowance also. That
No, this only gratuity is there in 72.
That is, they are in the petition, Lordship. We are claiming leave salary,
gratuity, leave salary,
and compassionate allowance.
Compassionate
allowance,
etc. Okay. That much you do it.
A date, Lord, please. A date may be kindly.
After 3 weeks, you
because otherwise it will not come.
Impress your learned colleague to get the criminal petition disposed of. That would be better.
I will impress.
Suppose if it is dismissed, we'll consider on its own merit this petition. If it is allowed, matter ends there, unless they took it to the higher, Supreme Court.
No, but we are not the party in that. The informant is a private individual. Bank was not the informant in that.
You are not interested.
No, actually,
Whether convict, not convict. Your role is only to take action
Was the
on being, on the petitioner being convicted, that's all.
The misappropriation was of a customer's money, not directly.
Okay,
Another civil case is going on in the Korimbganj.
okay, we're not concerned. You kindly impress your friend to get the things disposed of.